Yesterday, your Lordship has passed order regarding that SC, ST and OBC students in BSc nursing qualifying examination. There are two matters. Your Lordship has called some matters today at 52, item 52. So they have started the process. I have got two similar matters.
Don't make a mention. We have made general observation. If you can take advantage of that, you take that. Otherwise,
Your Lordship may kindly call it after lunch only.
sorry.
I am
Fair admission,
giving
my
these two numbers for consideration. I have given the two numbers for consideration to the department. I have already given the two numbers that is there in the case.
So if they have any, that is the general direction.
Yes, my lord, I have already given.
All right.
Fresh admission, my lord. Fresh admission. Fresh admission.
Fresh admission, the matters will be listed automatically.
No, it is a 2023 matter read appeal. And another one is contempt.
Why? The matters are urgent today.
It is not listed. Several memos are given before the day.
Why? Curing? All right, please wait for some time.
Lordship, item number 49. Your Lordship, item number 49 on today's list, we have filed for the petition. We filed an additional affidavit in that matter and the matter has not reached yet. It has been getting listed for.
When did you join? When did you join, Bob?
Quite some time.
So if any senior counsel is standing for making a mention, you should wait. All right. So Mr. Palit is there. All right. Yes.
Matter out of list.
Yes.
Item number 52. This is renewals of NOC of this nursing institutes. So your Lordship judgment was there, where your Lordship had fixed a timeline. So we have also complied with all the formalities well within the timeline.
They will also comply.
My lord,
Now, they are taking a plea, and it was, and we came to your Lordship's doorsteps, my lords, on 24/5/2024. Matter was noticed, and your Lordship has called for the instructions from them. During the pendency, now they are taking a plea that the time has lapsed. But there was no fault on our part. So I was praying with your Lordship.
We will see later.
Give us some time, my lord.
We will see later.
5158. 5158.
See, let us take up the cases instead of wasting time in making mentions. Yes.
Pardon.
My
Pardon to
senior for the department, he was suggesting that it may be taken up on Tuesday at 2 p.m.
2 p.m. all the matters.
Or give all your slips.
Yes, my lord.
We will decide.
52 and 58.
Give your slips.
Yes, my
Great.
lord.
So 50 to 58 will go. If any other matter is there, then you give the slips.
Grateful.
Tuesday.
Grateful.
Give your slip. Give your slip.
Yes.
My lord.
Matter is a writ appeal. Matter is relating to applicability of CCA rules instead of police matter. It's almost a part-hard matter.
Not almost. No matter is part. Yeah, of course. Give your slip.
Pardon me,
my lord, mention that your lordship.
I may be excused, my lord.
For listing of the matter
Give your slip.
29th of August, your
This
lordship.
is a fresh matter, my lord. I will be grateful Monday, my lord.
Please give your slip.
You want on 29th of August,
My lord,
mentioning 1 month before.
my lord, senior advocate Mr. Chidambar is supposed to appear the matter. That's why your lordship to regard to IPR of your lordship reimbursement of which withdrawn retrospective. That's why, my lord. 29th of August, my lord.
Never do this.
My lord,
Never fix a date yourself.
my lord,
I mean,
I
All right.
My lord.
Regarding withdrawal, I have filed two memos, my lord.
Withdrawal.
It is not coming withdrawal. my lord.
Withdrawal. Your withdrawal is not being listed.
Yes, my lord. I have filed two memos. It is not coming.
Tomorrow first, Monday first.
No,
Pardon, my lord.
Assigned bench I have filed.
Assigned bench.
Say that.
Because it is prior to 2014, the matter is not coming in there. Despite filing of it can be called in your lordship so that it can be.
Yes.
Pardon, my lord. My lord, item number 33, my lord. My lord, on behalf of my learned senior, Mr. Ranjan Kumar.
All right, let the matter be called. Yes.
item number 49, we have filed an additional affidavit that has not come on record, your Lordship. I'm requesting your Lordship to kindly direct that to be brought on record.
Which item?
Item 49. Your
So when the
Lordship.
matter is taken up and if your additional affidavit is not there on record, we will see.
And also, your lordship, the matter is pertaining to a tender matter, and actually there is some sort of urgency in that. So if your lordship kindly fixes that matter on any day in the coming week.
All right, if your matter is not taken up today, then make a mention on Monday.
Yes, sir. Maybe.
Tender matters, we shall give priority. Yes.
But item number 76 loss. This matter relates to the loss orders lawsuit passed to the director to chief secretary to dispose of all the loss representations pending. It is listed today along with the other writ application loss. In fact, we have filed a compliance affidavit. If the lawsuit can be pleased to take it up 2 o'clock, so that
We'll
dispose
take
of,
up.
because out of 5,000 crore, we have almost disposed of 3,674.
Great.
I'll give that details.
All right.
Pardon me, Lord.
2 p.m.
2 p.m. Lord.
Pardon me, Lord. Item 63, my lord. Item 6. Item 63, my lord. In this case, I have filed a contempt, my lord, because the order of your lordship passed in a writ appeal has not been complied. Interim order, my lord. Thereafter, your lordship directed to list it all writ appeals along with writ petitions pending before then it was listed, my lord. May I pray, Lord, my lord, it may be Tuesday, specific time.
Make a mention on Monday. Tuesday. Make a mention on Tuesday.
Today is listed, my lord.
Make a mention on Tuesday. If the matter is taken up today, it's all right. Otherwise, the matter will again be there on Monday and Tuesday also.
Obliged.
Item number 1.
May I please, Your Lordship?
Yes.
The order of the Honorable Single Judge at page 132, 132.
Annexure. 7.
Well,
Which annexure?
next. Annexure 3, ma'am. It starts from page 1 to 9. So first the court title, so I brought my lord's notice at page 132.
All right.
And the order starts from page 134, my lord.
Yes. Yes.
Well,
Yes.
may I read my
Please.
The petitioners who are applicants for the post of contract teacher Hindi in government high schools of Odisha pursuant to the advantage and issued for the recruitment year 2014-15. Madam, without reading entire judgment, I will draw my lord's notice to paragraph 8. Because it is
What was the qualification?
the qualification was prescribed. Your lordship can find it from that I have issued that annex that advertisement. Also, it is reflected in that judgment also at
Yes.
page 143.
143.
My lord.
Yes.
Also,
Yes.
Hindi teacher bachelor degree from a recognized university with Hindi as one of the elective subject with a minimum 50% mark in aggregate, 45% for SC university. But in this case, some difference is there that your lordship has seen, because your lordship has seen this qualification, and there are two types of qualifications. One in respect of trained. So far as untrained is that your lordship has seen that or part, or confers that in respect of untrained. May I read that or? bachelor degree with Hindi as one
According
of,
to you, there are two qualifications.
Yes, my lord.
One before or
yes,
and the other after or.
yes, yes.
So
yes,
either of the two qualifications a candidate must possess to become eligible.
to become eligible. That is the eligibility criteria.
Yes.
What has happened here, my lord? I'll specify my 3-4 dates, my lord.
Yes.
First date, your lordship, I have given on last occasion an affidavit for my lords that I have given those advertisements. Some dates are relevant, my lord. First advertisement was made on 23/10/2014.
Yes.
Their last date was 2011/2014.
Yeah.
Then my lord, next corrigendum was issued on 13/1/2015, extending the last
Date.
my lord 13/1/2015, extending the last date to 28/1/2015. In those advertisements, that the upper age limit was fixed to 32 years. That was challenged in a batch of petition before the state administrative
No,
tribunal.
32 years was
Up-
fixed.
Upper age limit.
Upper age in the advertisement, 23/10/2014.
Yes, ma'am. So that was challenged before state administrative tribunal in a number of original applications.
Upper age limit 32 years.
My lord.
Yes.
That was challenged before the state administrative tribunal in number of original applications. Those original applications were allowed and direction was given to extend their upper age limit to 42 years.
What ground?
Ground that recruitment
No
regulation was,
recruitment process had taken place.
My lord.
All right.
so that it was extended to 42 years without altering any terms and conditions of the earlier two advertisement. Only that age relaxation was extended to 42 years. So after that order, to implement that order, another corrigendum was issued on 7/1/2016.
Yes.
I'll bring my lord's notice that what is the last corrigendum.
Yes.
Your lordship may see that your lordship can find it from my affidavit. I have filed an affidavit that your lordship, that page 19.
Yes.
Your lordship, as per the order dated 17/12/2015 by the Honorable Administrative Tribunal Cuttack in way number so and other similar other cases, Government in School and Mass Education Department Odisha have issued a corrigendum number 284 published on 6/1/2000, enhancing the upper age limit from 32 to 42 in the resolution dated 234/404 dated 27/10/2014. Only those candidates, that is important, only those candidates who are eligible in all respect as per the eligibility criteria fixed in the advertisement and guideline published in paper and website on 23/10/2014 and 13/1/2014, and by the last date of receipt of fixed in these advertisements 2011/2014 and 28/1/2015, but would not apply for having crossed the age limit in this can apply.
So your last date was 21/8/2015.
28/1/2000, the
21/8 or 28/1?
28/1, my.
28/1/2015.
So, my lord, who are eligible in respect of other qualification as on 28/1/2015, but have not within that age group, only they can apply. This was the last corrigendum. So the eligibility criteria was fixed as on the last date on 28/1/2015. Admitted case of the respondents, they are not trained as on 28/1/2015.
Yes.
they have admitted in their writ petition, and it is also their admitted case that they have acquired that training qualification. They have, I have seen from their certificate, they have appeared the BD examination in July 2015. The result has been published in September, October, in between September, October 2015.
Yes.
Then I draw my lord's notice that judgment. This is our case is that as they don't have that requisite qualification, as on the date 28/1/2015, their case was rejected since they are not eligible. The Honorable Single Judge has held that even if they are not trained, they can be considered against the untrained post.
Whether the untrained posts were advertised.
Not as untrained candidates, sorry, not untrained, as untrained candidate that your lordship has seen that, or that the second part of that qualification prescribed. Your lordship may say that my lord Honorable Single Judge judgment.
Yes.
I may at page 144, paragraph 8. On perusal of the qualification prescribed for Hindi teacher, as mentioned above, it appears that only eligible candidates can make application for consideration of contract teacher Hindi pursuant to advertisement issued for the year 2014-15. Clause 3F of the advertisement, which has been placed in the bracket, makes it clear that the untrained candidates shall have to undergo required training within the timeline as prescribed by government. Thereby, necessary implication of incorporating this clause clearly indicates that though training qualification has been prescribed as eligibility criteria for making an application, the untrained candidates can also make an application, but they have to undergo required training within the timeline as prescribed by the government. It is not in dispute that the petitioners have got requisite qualification for appointment as contract teacher, but only difficulty is that they had not acquired the training qualification by the time they submitted the application, though they had undergone the training and the result thereof was not published. After submission of application, when result was published, before their applications were taken into consideration, even though produced the training qualification certificate, their application were rejected, stating that BD after 6/4/2015 or certificate produced after 6/4/2015. The grounds for rejection of their application cannot sustain in view of the stipulation made in clause 3A of the resolution dated 27/10/2014. If untrained candidates have right to make application, subsequently they can undergo required training within the timeline as prescribed by the government. Submission of their application, even as untrained candidate, cannot be said to be faulted with. Rather, their application should have been considered as untrained candidate for selection to the post of contract teacher Hindi, and they should have been allowed to undergo required training within the timeline as prescribed by the government. As such, the present petition stand on a better footing in accordance with the stipulation made in clause 3F of the resolution dated 27/10/2014, meaning thereby, even though they had applied as untrained candidate and undergone training, but result there was not published by the time they submitted their applications. But before consideration of their application, they had already acquired the qualification of training, and thereby application should not and could not have been rejected by the authority stating BD after 6/4/2014 or certificate produced after 6/4/2015. And as such, the disqualifying them from participating in the process of selection is absolute non-application and made by authority and unwarranted. Similar view has already been taken by this court in Nihar Ranjan Sadai. In Banarasi Das versus State of UP, year 1956, Supreme Court 520, the Apex Court held that it is open to the appointing authority to lay down requisite qualification for recruitment to government service. Although the candidate must fulfill the requisite qualification for being considered, for recruitment difficulties often arise with regard to the interpretation of the requisite qualification. Since the qualification vary from case to case, decisions have turned upon the construction of the specific requirements provided by the rules or administrative instruction in the particular cases before the courts. It is also brought to the notice of the court that untrained persons have been given engagement by order dated 4/4/2016 in respect of Mayurbhanj and Balangir Education District. Thereby, it is contended that even though untrained qualification had not been taken into consideration, but as untrained candidate, their case should have been considered and engagement order should have been issued in their favor, as similar situated persons have already been extended with such benefit. As such, the interaction of the gross violation of Article 14 and 16 of the India.
But what is wrong? In fact, there are two categories.
Yes, ma'am.
One trained and the other
another
untrained.
untrained.
So untrained candidates were also eligible.
Yes,
As on 28/1/2015.
my lord, subject to fulfilling the eligibility criteria for untrained candidates.
Yes,
If they fulfill,
absolutely right.
yes,
So if they fulfill this or criteria,
yes,
untrained, bachelor degree with Hindi as one of the options, subject with minimum 50% of marks.
yes,
So this they must.
they don't have that qualification.
So they don't have the or qualification.
Yes, if they have the qualification as prescribed under or, then they're eligible, they become eligible and they're bound to be considered. To that fact, there is no dispute.
So, but what is their case then?
Their case, they are trained.
All right, they are trained because they are trained, and though their results were not published.
Yes, they at that part of time, I think
No, they whether they are claiming their eligibility under the first clause of.
Yes, they are claiming eligibility under the first clause,
Not under the.
not under the or clause. So the
This untrained in the present judgment has been read with the first eligibility.
This, that
No, this was challenging an order.
Honorable Single Judge has held that they have that requisite qualification without going into the facts that whether they have that.
There can be two situations. Like if this untrained part is read with the first qualification and also with the second qualification, then the judgment becomes correct.
Yes, ma'am.
If this interpretation is given, that this untrained candidate shall have to undergo, if this is to be read with the first part also.
The last part cannot be read with the first part.
Maybe you are right, but our question is that is this the logic given by the learned single judge?
There is no logic to that effect. Only Honorable Single Judge has.
Only, all right. So learned single, therefore, they are saying that the situation is same. If the learned single judge, by reading this part of the qualification, records that those untrained were also eligible and their cases ought to have been considered, that would mean that the learned single judge considered this untrained part together with the first qualification and the second qualification also. All right, your submission, that this cannot be read with one.
Yes.
It can be read with two only.
Yeah, because these are two independent.
Two independent qualifications. This is your submission.
Yes.
All right.
Because why they are two independent? If they will be treated as trained, they will cover on the first part. If they will be treated as untrained, they will cover under second part. It is the admitted fact that they are not trained as on the last date of the cut-off date. There is no dispute that, and it is the admitted fact that they are untrained as on the cut-off date. And their case was, what was their case before the Honorable Single Judge Elosme see their prayer?
Yes.
Elosme, may I point my page 58 of my brief appeal.
Yes.
It is the stand. Fact remains that Elosme see the last 5 lines, page 58.
Yes.
Facts remain that the applicant though was untrained on the date of advertisement, but it appears that the applicant has already acquired training qualification BD from Dakshina Bharat University, which has already been declared to be equivalent to that of BA in Utkal. In such background, even the applicant has acquired training qualification after the advertisement, but there is no reason yet to why the candidate shall not be considered against the untrained vacancy of the contract teacher, particularly when they are satisfied their age criteria so and so. Then you will also see the prayer. Not to reject on form of the applicants, they have allowed to participate in the selection for the post of contracting in the persons who are paid students. The certificates which they have given, the lordship may see their certificates. Why I am saying they don't have that qualification under the cover of that or untrained.
Which certificate?
The certificates they have annexed.
So that is not in dispute.
That is not dispute. That is only if your lordship will come to that conclusion, they are covered under that untrained. So they don't have a case. If they will be covered under trained, they don't have that requisite qualification as on the last date. This is the case before my lords. And the Honorable Single Judge has held that even if untrained, they are to be considered.
That's all.
So that is the only case. If our case,
Where is that decision?
my lords,
Where?
sorry, my lord, that only one copy.
All right, all right.
What is the number? Okay.
My lord, to that untrained qualification, your lordship may see my grounds at K, page 28. It starts from 20. Sorry.
But where is that specific conclusion dealing with this? See,
That I was submitting that in respect that equivalence that
not equivalence. Not the equivalence, interpretation of this clause.
Then the this issue.
No, in the so in some case, we have specifically held that these are two qualifications.
So that was another judgment.
That must be another judgment.
Yes, ma'am.
Yes, all right, we can decide and discuss also.
My lord, before that, my lord, I'll bring to my lord's notice only to para K, grounds K of my writ of appeal, my lord. Page 28. My lord has asked me the regarding that untrained qualification, why we do not consider their case. Page 28 of my appeal.
Yes.
Further, the judgment delivered by the Honorable Single Judge is under misconceptions of fact that as there is provision for selection of untrained candidates in the arbeit, there is no justification in rejecting the candidates for having passed training after the cut-off date. While misconstruing the fact on the basis of misleading argument of the petitioner of the Honorable Single Judge, Miserable failed to appreciate the fact that for untrained category, there was a separate set of qualification prescribed in the advertisement. For considering candidate under untrained, a candidate need to apply under untrained category and need also enter the qualification mark in respect of. Further, from the affirmance in the petition, it indicated they had not passed BA with Hindi as a subject, which that is the requirement of untrained. BA with Hindi as a subject, which makes it clear that they are also not eligible under untrained category. Last sentence of that paragraph.
Yes.
And I've shown my lords that or part, that untrained part, the specific qualification that what? Bachelor degree with Hindi as one of the optional honors subject with minimum 50% of mark. That they don't have. So they cannot be considered as untrained. This is the case only.
Yes.
I appreciate. There are other counsel, but so far as I am appearing in the first case, very short date of events. (27/10/2014), a resolution was issued for recruitment of teachers in government secondary school, where under clause 3F dealt with the qualification
This
for
is
the
27 or 23? 20, Mr.
page number, yes, page number 68. 27/10/2014.
27.
Page 68.
27, all right. Yes.
A resolution was issued for recruitment of teachers in government secondary school, whereunder clause 3F dealt with the qualification for the post of Hindi teacher, fixing the upper age limit to 32 years. The last date of submission of the application was fixed 2011/2014. That is Annexure 1 at page 68. 6/1/2015, pursuant to the advertisement dated 27/10/2014, an amendment related to recruitment of contractual teachers was published, whereunder the last date of submission of the online application form was extended to 28/1/2015. That is at Annexure 5 at page 13. July 2015, all the respondents, private respondents, have appeared in the B.Ed examination and were declared pass thereof. That is at Annexure 1 at page 79 of the writ application. Then 17/12/2015, the London State Administrative Tribunal in way number 3589C of 2014, vide order dated 17/12/2015, enhanced the upper age limit for the candidate from 32 years to 42 years. That is Annexure 7 at page 25. Then you also kind mark, this is important, 7/1/2016. In terms of the order dated 17/12/2015 passed by the London Tribunal, a fresh corrigendum was issued by the appellant number 2, enhancing the upper age limit to 42 years. Accordingly, the last date of the advertisement was extended till 22/1/2016. That's kindly pause for a moment. Admittedly, by 22/1/2016, all the respondents have appeared the B.Ed examination and have declared to have passed in July 2015. Now, the question for your consideration, as Mr. Kutia, the additional government advocate raised, that we have admittedly acquired the qualification after 28/1/2015. There is no dispute it. But before 22/1/2016, in the corrigendum which was issued pursuant to the judgment passed by the tribunal, that was on 7/1/2016, the last date was kept to 22/1/2016, by which date we have acquired the qualification. Then let's come to the next page. 2016, as and when the present respondent could not submit their online application pursuant to the corrigendum solely on the ground that the respondent have acquired B.Ed qualification after the last date of the advertisement, that is, before the corrigendum was issued, finding no other alternative, they approached the tribunal in way number so and so. On 24/2/2016, the Law and Tribunal passed an interim order to consider the case of the petitioner respondent as untrained Hindi teacher as per the resolution dated 27/10/2014, if they are otherwise eligible and possess the requisite qualification, but their results shall not be published. That has been kept in civil cover. Then on 15/9/2021, Honorable Single Judge allowed the writ application preferred by the present respondent. Then 24/2022, as against the judgment dated 15/9/2021 passed in WPC number OSC number 902 of 2016, the present writ application has been preferred after a delay of 6 months. Let's just skip over. Then 29/11/2022, an identical matter relating to a Sikhas Act, where also the delay, the overage was condoned. Identical, I'll show you also. A writ appeal bearing writ appeal number 102 of 2016, Vishwaranjan Mishra and others, versus State of Orissa was filed, and the Honorable Court, by judgment dated 15/9/2021, allowed the writ appeal directing the School and Mass Education Department to issue appointment letter as junior teachers within a period of 8 weeks, taking into consideration they have acquired the training qualification prior to the last date of the corrigendum to the advertisement. I'll come to that later on. But before I take your lordship to the merit of the case, your lordship again look to the judgment, impugned judgment. The impugned judgment, the Honorable Single Judge.
No, Mr. Rautra, why should we see the impugned judgment when the facts are admitted?
Yes, sir.
See,
Why
the entire case depends upon the interpretation
Right.
of the
Right.
eligibility criteria.
Right. Sure.
And two, whether because of the last corrigendum,
Right.
you can be said to be treated to be eligible
Right.
because on that date you had acquired qualification,
Right.
despite specific prescription in the last corrigendum that those who were eligible,
Yes.
only they shall be considered.
Those who have
And see the circumstance in which the last corrigendum was issued. That was issued apparently because of certain order passed by the administrative
Right.
tribunal. Administrative tribunal must have directed to enhance the upper age
Yes.
limit. That was in the background, that in the meanwhile, no selection process
yes.
was taken up. And therefore, though such persons who had the qualification could not avail the opportunity of participating in the process of selection. And that corrigendum was in that background.
Right.
That corrigendum was not in the background that even those candidates who acquire qualification subsequent to the second corrigendum should also be
My
considered.
respectful submission is this. If the law laid down by the Honorable Apex Court, you have also occasion to deal with those matters, which has been also referred to the division bench. If the rule prescribed, that this is the last date of submission of the application, then question is different. If rule is silence, then always the last date of submission of the application pursuant to the advertisement or corrigendum, that will be the last date of submission of the application. By that date, you must acquire the qualification. Kindly have a look to that.
We will examine any judgment. Everything will depend on the nature of advertisement.
I'm putting a question to myself.
Yes.
Sir, those who are before lordship, most of them, those who have approached the tribunal and tribunal said that instead of the 32 years, that will be 42 years. And those person, for those person, a corrigendum was issued, even if we go to that extent. The last date of corrigendum, last date of submission of the application was the 22/1/2016.
Yes.
So by that date, 22/1/2016, those persons have already acquired that qualification of.
Where is that corrigendum?
That is at, I'm sorry that is at
Page 66.
page 66,
It is not there.
page 66 of the writ appeals.
66 is the guidelines.
That guideline not respected.
Guideline is the corrigendum.
That is along with this, yes, let me see that. That is, they have issued it for the purpose. Page 75.
Page 75.
Page
66
75.
what is sir? Sir, 66 का इधर था, ये guideline.
No, no.
It's the guideline, corrigendum. हाँ, sir, corrigendum.
Page 75.
ठीक है टीम कोई दो
And the neat copy at page 19 of the affidavit filed by.
तका activities at page 19.
75 corrigendum.
19 of
Their affidavit, that will be better. You also look to their affidavit.
19 of their affidavit.
Yes. You also look to their affidavit. Page 19. Also look to page 19. I think you also get it there. They have filed an affidavit, independent affidavit.
Yes.
Page 19, Annexure 6. You also see this. As per the order, so-and-so of the Orissa Administrative Tribunal, Cuttack in so-and-so, in Government School of so-and-so, have issued corrigendum, date number 284, published on 6/1/2016, enhancing the upper age limit from 32 to 42 years in the resolution dated 27/10/2014. Only those candidates who are eligible in all respect as per the eligibility criteria fixed in the advertisement and guideline published in the OPEPA website on 23/10/2014 and 13/1/2015. And by the last date of receipt of the application fixed in these advertisement 2011/2014 and 28/1/2015, but could not apply for having crossed the age limit fixed in these advertisement can apply now. The detail of the advertisement will be available in our OPEPA website from 7/1/2016. The last date of online application is 22/1/2016. And if you also look to that 2011/2014 and 28/1/2015, nowhere in the advertisement the last date has been fixed. They were also eligible.
What
The
is-
We have understood.
What
Sir,
is the
sir,
meaning
sir.
of the
So the
corrigendum?
eligibility criteria was fixed.
Here, opportunity was granted to the persons because they were age barred, not because they had not acquired the qualification.
Sir, that is not the qualification. There was, so far as those two advertisements is concerned, that 2011/2014 or 28/1/2015, there is no last date of submission of the application. Whereas on this corrigendum, they have fixed the last date of online application to 22/1/2016.
Its last date means you could have applied after the advertisement also.
No,
You're
no,
saying
no.
first to advertisement, there was no last date.
As rightly, my Lord, Honorable Chief Justice said, that because the process of the selection was not there, so they, lastly, this corrigendum was issued, they fixed the last date to 22/1/2000.
So the simple question is that the first last date for submission of application was 2011/2014.
Sir,
The second last date for submission of application was 28/1/2015. All right. Now later, there was an order passed by the administrative tribunal, and because of that, certain persons who were not eligible because of the age, they became eligible, and for them, the last date was extended to 17/1/2000, sorry,
22/1/2016.
22/1/2016.
2016. Sir, we are the persons.
And in the corrigendum, it is specifically mentioned that those who were otherwise eligible, apart from the age criteria, those who were otherwise eligible, only as on 28/1/2015 would only apply. So a person who was 34 years, all right, and had the qualification as on 28/1/2015, he could apply.
Yes.
That is the,
Madam. So far as we are concerned, we are also that overage, that category of overage.
you are overage, but you are not
But that-
qualified on that.
We could not have made an application pursuant to the first advertisement or the first corrigendum. We could not have because of the overage. So we only.
See, you could not have applied against the first advertisement. You could not have applied against the second advertisement. You could not have second this thing corrigendum. First corrigendum. You could not have applied after the second corrigendum also because you did not have the qualification as mentioned in the corrigendum as on 28/1/2015. That is the case.
That is exactly the point. So far as the second point is concerned, if your lordship will accept, as has been held by the honorable single judge, that bracket portion will be applicable to both category, or because it is or.
Yes.
Then position is different because I have the right to be considered within a period of 3.
Absolutely right.
That's right.
Absolutely.
So that part you'll also keep it above. And that judgment, but before I take your lordships to at least kindly look to one judgment of division bench of this court, recent judgments on the similar circumstance.
Yes,
That is flag I of my affidavit. I have enclosed at page 6. Sorry, page 14. Page 14.
Page 14 of
that flag I.
flag I.
Yes.
No, they don't mention.
Affidavit in reply.
Affidavit, yes, filed by the respondent. Affidavit filed by the respondent. Dated 2/4/2024. But you get it? Okay.
Yes. The index, they are not giving the flag. Not given that. All the cases there.
I think it is it is in the flag I we are getting from.
Okay, page 6 or which one? Page 6?
That has not been.
We found it. Page.
Yes, page 16. Let's get it.
Vishwaranjan Biswal.
Yes. My Honorable Chief Justice, I think.
Yes.
Yes, Lord. Let's say kindly look to para 2. What is the background? Exactly. The background fact are that each of the appellants, here the appellant was the private parties, because single judge has decided in favor of the state. The background facts that each of the appellants acquired the BA degree and thereafter appeared in the OTET, Orissa Teachers Eligibility Test, Part 2, conducted by the Board of Secondary Education, Orissa, in December 2014. The results were published in the month of March 2015. There are 2 guidelines issued by the School and Mass Education Department regarding engagement of Shiksha. The first guideline was dated 6th August 2013, where inter alia, Clause 6, Category 2 prescribed that the candidate should have possessed the OTET Category 2 amongst other qualifications. As far as the age was concerned, the candidate had to not below 18 years and above 35 years. And in case of scheduled caste, scheduled tribe, women, ex-serviceman and SCBC, the upper age limit could be relaxed 5 years, and in the case of PH candidate by 10 years. On 11 September 2014, a revised guideline was issued regarding engagement of Shiksha during 2014-15. This inter alia stipulated that, in matter comma, passing required training and score in OTET is a mandatory for all candidates. As regards the age limit, it was to be determined as on 12th September 2014, that is the date of publication of the advertisement. It transpires that as regards the non-relaxation of age limits for the specified categories of person, WPC number 6670 of 2014-15 was disposed of in the court. In pursuance to the order of this court, passed therein, the last date for submission of online application for the post of Shiksha was extended for the candidate within the age group of 35 to 42 years as on 30th September 2014, with relaxation of 5 years for scheduled caste, scheduled tribe, SCBC women, and 10 years for physically handicapped candidate. It is only by virtue of this corrigendum, which was provided for the relaxation of upper age limit, that the 3 writ application, the appellant herein, became eligible to apply for the post of Shiksha Sayak. Under the earlier advertisement dated 12th September 2014, they would not be eligible. In terms of the corrigendum dated 9th April 2016, the last date of submission of the application was 28th February 2016. The appellant contended that they had possessed the requisite qualification of OTET 2 in March 2015, which was before the last date of submission of the application in terms of the corrigendum, and therefore their candidature could not have been rejected on the ground of lack of requisite qualification. The stand of the School and Mass Education Department, on the other hand, was that since the purposes of determination of age as per the enhanced age criteria, the relevant date was fixed to 30 September 2014, the qualification also had to be obtained as that date. The Lord Single Judge accepted the plea of the department that the corrigendum related back to the original advertisement itself, and therefore the cut-off date for determining whether the candidate had possessed the necessary qualification had to be the same date for determining the age, which was 11th September 2014. Lord Counsel for the appellant has drawn the attention of this court to the judgment of the Supreme Court in Rekha Chaturvedi versus so-and-so 93 supplementary 3 SCC page 168, wherein inter alia in paragraph 10 it was observed as under quotation. The contention that the required qualification of the candidate should be examined with reference to the date of selection and not with reference to the last date for making application has only to be stated to be rejected. The date of selection is invariably uncertain. In the absence of knowledge of such date, the candidate who apply for the post will be unable to state whether they are qualified for the post in question or not, if they are yet to acquire the qualification, unless the advertisement mention a fixed date. Unless advertisement mention a fixed date with reference to which the qualification are to be judged, whether the said date is of selection or otherwise, it would not be possible for the candidate who do not possess the requisite qualification in presenting, even to be in the application for the post. The uncertainty of the date of marriage will lead to contrary consequences, even those candidates who do not have the qualification presently and are likely to acquire them an uncertain future date may apply for the post, thus swelling the number of applications. But still worse consequence may follow, in that it may leave open a scope for malpractices. The date of selection may be so fixed or manipulated as to entertain some applicants and reject others arbitrarily. Hence, in the absence of a fixed date indicated in the advertisement of
Mr. Rautray, are you required to read this judgment? This is settled position that if qualification is mentioned and last date is fixed,
right,
there is no prescribed rule, no prescription in the advertisement as to what should be the cutoff date. The last date of submission of application should be treated to be the cutoff date for the purpose of determination of eligibility. There is no doubt of this legal.
I do.
There can't be a quarrel.
Sir,
The question is whether in the present set of facts, in terms of the last corrigendum, whether it can be said that you fulfill the eligibility criteria.
Right.
So it will depend.
But this is a case where only after the corrigendum was issued, exactly on the ground of that age criteria, for them a corrigendum was issued extending the date of submitting the application, and the application were submitted within the date.
Your course ought to have been, you ought to have challenged the corrigendum on which you are placing reliance, that on 2016 corrigendum, but you could have challenged that see that there is this stipulation, and you could not have successfully challenged even because that corrigendum had a definite purpose.
So that exactly what my humble submission is. This is a judgment where also on the similar fact and circumstances, a corrigendum was issued because of the age criteria was enhanced, and that the last date was original advertisement was something else, and the persons, those who made the application, within the last date of that corrigendum.
We are putting another question.
Sure.
Was in that case a situation where while enhancing the age criteria, it was stipulated that the qualification eligibility conditions should be the same as was mentioned in the advertisement? Is there any discussion on this point?
So far as the judgment which was passed by, because that was a case where the single judge had decided the matters. Yeah.
No, single judge had decided the matter. Thereafter, the divisional bench discussed everything. But whether this fact has been dealt with, this is the aspect.
I have to check up because
you cannot check
because,
up.
because this has been quoted here.
Mr. Ratra, you cannot check up.
This has been quoted here.
Please. You cannot check up based on the pleadings of that case, because we don't read pleadings while considering a judgment as a precedence. So what has been held, we are required to look into that only.
So, if you Lordship,
that is the
my respect to submission. If you Lordship look, the ultimate conclusion of this court in that case, referring that to judgment of the Supreme Court, if the ratio of, as your Lordship will accept that, the last date of submission of the application as per the corrigendum, then we have acquired the qualification. There is no doubt about it.
Absolutely right.
That's right.
You are absolutely right. If we give that interpretation to the second corrigendum, then you have a case.
Only I am still in doubt. But I put that question to myself. I could not have made the application as per the first advertisement or the first corrigendum. The second corrigendum, which was issued only terms of the judgment of the tribunal, because we are the beneficiary of the judgment of the tribunal, and by that date we have already acquired the qualification. That is what that is a. And the another point, if you also look to the entire judgment, in fact, that is the crux of the matter.
Just think of a situation. If a person was not eligible, say when the first corrigendum was issued, up to 28/1/2015, he did not have neither age, he was say 34, and after this he acquires the qualification
in July 2015. Right. That
so all right. Do you suggest that as a senior counsel that this court, all right, as a counsel for
my clients,
that we should deviate from the terms of the second corrigendum? That is the only point.
If my submission, if I confine to my submission, so there cannot be any deviation because ultimately the corrigendum, second corrigendum, because I have to make an application.
No, how do you deal with that part of that corrigendum? That only those candidates who were qualified on that date will be eligible.
But still,
how can
that first corrigendum or the advertisement, so certainly I could not have made because of my age. Your Lordship says because of the other conditions which you are not satisfied by that time. So only for the purpose of age I have approved.
All right. So is there any decision that despite such condition in the in the corrigendum, the court can deviate, and the last date as fixed in the corrigendum should be the last date for fulfilling the eligibility criteria? Shall be the date which shall determine the eligibility criteria. Crucial date for determining the eligibility. That is the only question, Mr. Rao. And you appreciate better than us the legal issue.
So for that part, you'll also kindly.
Second part, because you are not accepting.
Because I will not try
the last sentence you are not accepting.
My accepting, not accepting, not a factor at all. But the other thing which my duty is to bring to your notice, because other counsels are there. So far, the first argument is concerned that bracket portion is applicable to both the judgment, the impugned judgment independently consider that this is the entire eligibility
that
correct.
will-
That's it. And that judgment, in the impugned judgment, a judgment has been relied upon. That judgment of another coordinate bench has been relied upon. I have given that copy of the judgment. Also look to that. Also look to impugned order at page 146. Similar view has been taken by this court in Nihar Ranjan Sadhan case. Nihar Ranjan Singh. Also look to page 146 of the judgment. Relied upon that Nihar Ranjan. Same thing. And this Nihar Ranjan Singh judgment I have enclosed at page number 6.
No, the crucial point for determination is, was there the same stipulation in the corrigendum as is there in the present case?
The same things. Nihar Ranjan case is the same case. Same. Arising out of
Like
same.
only such who were fulfilling the eligibility condition on the date of on the cut.
This here is a case of on train. The first part of the argument.
Not the question. That is not the.
Yes, same advertisement. Same advertisement, same guidelines, same. I've enclosed that judgment. Why I'm saying so, this judgment has been upheld by the division bench, and they have gone to Supreme Court. Matter is still pending. I was told that no interim order has been passed.
No.
You also look to page 6, that judgment.
See, we do not find any serious legal issue involved in the present case.
Then that is for your
Maybe pending.
And the fact remains, the large number of vacancies are available in so far the Hindi teachers are concerned. And in fact, by the virtue of the order of the tribunal, they have made the application. Their applications have been considered, but it has been kept in sealed cover. In the other case, so far the Sikha Sahak is concerned, this honorable court directed for opening of that sealed cover. They found that this stands in a much better footing than the other meritorious candidate. Their merit position is high. Then the lordship directed for to give them appointment. That the case which was citing with your lordships. Always your lordship's discretion is always available.
No.
Always.
We don't.
So far the law, what I've understood, it can be stretched by your lordships to that extent.
Never.
Unless it is unless it's directly contrary to any provisions of law.
The first duty of a court is to identify its own
jurisdiction. I can't.
Within the confines of the jurisdiction.
This side, I can't go to that extent. No, what I'm trying to say that Nihar Ranjan case, you should kindly look to page 6 of that affidavit. At flag I.
Page 6. Yes.
Same mirror. You also come to para 5, then 6, page number 8. Pursuant to issuance of notice, the opposite party number 3 filing a counter affidavit attempted to justify the action of the opposite party not selecting the petitioner recruitment process in question. Mr. Mishra and signing counsel for the School and Mass Education Department drawing the attention of this court to the pleading made in paragraph 6, 7, 8 of the counter affidavit contended that petitioner did not have the Hindi training qualification such as Hindi Sikha Parangat or B.Ed in Hindi. The authority are justified in not selecting the case of the petitioner. In the above premises, Mr. Mishra and standing counsel for the School and Mass Education Department requested this court for dismissal of the writ application. Considering the rival contents of the parties, this court finds the moot question remains to be decided in this matter is if the petitioner meet the required qualification criteria for being selected in the post of contractual Hindi teacher in the government school in 2014-15, pursuant to the resolution by the Annexure 4, whether the authority are justified in not selecting the case of the petitioner, the question mark. As it appears, both parties rely on the same resolution by the Annexure 3, prescribing qualification criteria for the selection public eligible purpose. The provision at clause 3A of the resolution being relevant for adjudication of the question involved herein. This court here likes to take note of the same, which is reads as follows. That page, see that page 10, down below, that bracketed portion, the untrained candidate shall have to undergo the required training within the time limit as prescribed. Same thing, same stipulation, that the very same advertisement. 7. On reading of the aforesaid clear provision made in this resolution to make a candidate eligible to apply for the post of contractual Hindi teacher in government secondary school in 2014-15, this court finds there is a prescription of so many qualifications prescribed herein for one becoming eligible to apply against the post of contractual Hindi teacher. And one such qualification is one must be having bachelor's degree from a recognized university with Hindi as one of the elective subject with minimum 50% mark in aggregate, and in case of Silka Siltribe, minimum 45% mark in aggregate, or with Rashtravastha Ratna from Rashtravarsha Prachar Samiti, Wardha, or with Shastri from Orissa Shastravastha Prachar Samiti Puri with so-and-so. Acquired by June 2005, the date of which the temporary recognition has been granted from Hindi Shiksha Samiti. They have quoted from the advertisement. This being the required qualification, on reading of the counter affidavit, this court find there is no dispute as to the petitioner having a bachelor's degree from a recognized university for Hindi teacher by way of Rashtrabhasha Shastri under the Orissa Rashtrabhasha Parishad Jagannath Dham, Puri. And on entire reading of clause 3F of this code, nowhere finds the requirement of Hindi training qualification for Hindi teacher. Further, for the bracket portion, below the condition 3F, providing opportunity to provide training after being eligible qualified, the stand of the department that there was requirement for training remains unfounded. In such view of the matter, this court finds the stand taken by the contesting opposite party remains wholly contrary to the condition at clause 3F in the resolution by the Annexure 4. It is in this view of the matter, this court finds the ground of not selecting the petitioner is not germane to the condition imposed in the resolution by the Annexure 4. As a consequence, this court finds not selecting the petitioner for the post of contractual Hindi teacher pursuant to the advertisement in question is illegal. Since the petitioner was fulfilling all the required qualifications for the post of contract Hindi teachers in the government school in 2014-15, pursuant to the resolution by the Annexure 4, this court directs in the event the petitioner fulfill other conditions, the competent authority to draw a fresh select list of contractual Hindi teacher in government school pursuant to the advertisement in question forthwith, preferably within a period of 1 month. And in the event the name of the petitioner find place within the required candidates, the petitioner shall be appointed against the said post. In the event there is possibility of disturbing any of the selected person, such person may be provided with opportunity for the petitioner going to get the benefit through the judgment as the litigation process involve the petitioner content for 6 years or so keep over the directive for withdrawal of fresh selection. And this judgment was challenged by the state before the division bench rate appeal, intra-court appeal. That has been dismissed, of course, on the ground of limitation. And this has been also challenged in specially petition before the Honorable Appeals Court. That matter is still pending. This is the...
No, that is different. That must have been challenged on the, again, because that division bench decision has been, the
limitation.
court appeal has been dismissed on the ground of limitation. Only that aspect.
But the court has issued notice and matter is now pending. They have raised all these questions before the Honorable Appeals Court. That the present impugned judgment is opposite of the judgment of the earlier one.
But still, I am not finding that decision where I have this bench has.
Your Lordship has, yes, I remember that one case your Lordship is dealing with that.
Short order, but.
Short order.
Yes, fine. All right. All right, let him come. Let him come.
This is so far as my and there are other cases. There are about large number of writ appeals which were filed. Since terms of the judgment, that Neharkant judgment, and also this impugned judgment, various cases have been disposed of. They preferred appeal, and the appeal have been dismissed. They have not challenged also in many cases before the. So far that judgment is concerned of the. In terms of this judgment, that has become final because that attained its finality. It has not.
We will deal with that judgment also. Neharkant judgment we will deal with.
You'll
deal with.
Your lordship will deal it.
Since you are relying on that decision, we shall deal with that judgment.
And in some cases also, as my right friend said, they have not challenged it in writ appeal.
We don't know. We will see the advertisement. We will see the learned single judge's decision and the judgment which you are relying on. If you have to show some other decisions, some other orders, that's a different matter.
That's why grant me some time.
Let us see.
Yes.
Yes, that's.
But at least some other day so that I can at least to meet your lordship's story. So for the question of law which your lordship is raising, let me try to at least.
Sir, you have filed your affidavit. You must have, your junior must have done the research work. All right. Yes, Mr. You are appearing for?
I have filed a petition for intervention here because my case was also disposed of along with those cases. I have been in independent cases, but common judgment was passed by the Honorable Single Judge. They have not filed an appeal against my case. That is why I am feeling problem.
Why are they favoring you?
Pardon me?
I am favoring you.
The intervenor because the common judgment now.
In that case also you are intervener.
No. I was an independent
Therefore,
case. All the cases clubbed together. Common judgment was passed, which is imbue. Now my case was slightly different in this sense. Other arguments I have along with my senior. The client I am appearing, standing here, my lord, he has the qualification prior to the cut-off date. But because all the cases were disposed of and they didn't choose to file an appeal against my case. But if the judgment will go, no, not that, because common judgment has passed. My difficulty is a common judgment passed, case was allowed. So we thought that yes, we will get an appointment. But now they're challenging it without challenging my case. That is why I filed the writ appeal. No, sorry, intervention petition, my lord. If they will file a writ appeal against my case, this judgment may save for me, my client. That is the difficulty I am facing because what I will submit, it is beyond the record. Because my writ petition is not there before my lord. They are not choosing to challenge it. But if judgment will go, I will know.
Would we allow your intervention application then?
Intervention, then, my lord, if that my application is there, my lord, if that will be allowed, I may be given an opportunity to file the document, at least my writ petition, my qualification.
No, your writ petition we will call for the record.
Yes, that may be called for. My application number is IN number 7675 of 23. Flag F. Qualification prior to the cut-off date, what they are now saying. That is the only point because I will argue if my senior will complete this training qualification, that
No,
Hindi by this date, 39/2014, they have said. Initially, what is the case, my lord? Before the original application, but I was overaged, I could not apply. Now they have extended.
You have a different case altogether.
But this my difficulty is, my lord, the case was disposed of by the common judgment.
Mr. What is this? See, when did you have the qualification?
I had the qualification, my lord, prior to this cut-off date. That is why I am saying, well, because I just now.
Therefore, they have not challenged your the judgment in your case.
Kindly visualize my problem, my lord. If the judgment will go, my case will go.
No, the judgment will. We shall clarify that those who are eligible as on 28/1/2015.
My lord.
Their cases are to be considered.
Then I am safe. Then I am safe. Then I am safe. Then I am safe.
We'll take note.
On the other day, I will clarify, my lord, with my document. I have.
What document, sir?
I have to place that yes, I have passed it. I have to show to my lord also.
We will clarify. We will clarify that.
Oblige.
Clarify in the.
Then we will save, my lord. Some person will save.
We will clarify.
My lord.
That's all, Mr.
And I have same like my senior Mr. Das, intervener. No independent appeal has been preferred.
No, whether you are also qualified as on 28/1, then we will clarify that.
Yes.
We will clarify in no uncertain terms, in no unambiguous terms, we shall clarify that those who held the eligibility criteria as on 28/1/2015 in terms of everything other than age. All right, their cases shall be considered if that there is no.
That will save.
So far as that 3F, which has been interpreted well, first we keep it to some other.
Oh.
PF also.
3,
We will give, we will interpret that.
yes.
That
But 3
bracketed person.
bracketed portion.
Bracketed.
It applies to both, not only confined to the second one. That is the first question, Lord. A second question comes only.
So first question you have argued.
No, first question this, that what the judgment by the single judge and the Niyaranjan case, they have both the judges, the coordinate bench, they have said by reading together the whole of the
All right,
advertisement.
when do you want?
I want that will be applicable to for both.
When do you?
Next week, next
Next
week.
week, this matter on to be taken up as the first case. As requested by Mr. Senior Counsel appearing on behalf of the respondent. Contesting respondent. Next Thursday.
No, well, so we are the on-trend animal, so we have the eligibility qualification.
They are the effective person.
And some similarly on-trend persons have been given appointment by the state government. And in other cases, they have gone to Supreme Court and the SLP has been dismissed also, on limitation ground.
My lord, we'll file a written note. My lord. Give. In the meanwhile, you can do that.
Well, our case is little different, my lord. We are on trend, my lord.
All right.
Item number 2.
My lord, before my learned seniors start the case, my submission is I had given my regulation of the committee that their cases in the cases where we have given them NOC after the cutoff date. So we will allow those institutions for consideration of their case this year. Though as per my lord direction, the cutoff date is over, but there is scope for them giving admission and getting them that is my submission. So that
When will you do that?
My lord,
When will you do that?
within 5 to 7 days, they will provide us, we will do it.
You will provide?
5 to 7 days, we will ask them to provide their documents, what is essential, the fees and all that, so that we can immediately.
All there with them.
If it is there, we will check up and we will give them NOC, allow them to get admission and all that.
Because where application is pending.
And we will consider their case. That is what my submission is.
Consider means you should grant, otherwise.
We will grant NOC, and we will allow the students for getting affiliations by telling to the university, and we will see that they sit in the counseling for admission to the course.
First thing which you are required to do is
Yes, sir.
that you should file an application before this court that you intend to do it. Please allow.
My lord,
We will allow.
my lord, my resolution I have said, as in, may I read it, my lord?
You have come out with a resolution.
Yes, my lord.
Please give him.
That resolution is there in the counter they have filed.
Yes, yes.
When?
Yesterday they filed, my lord. Yesterday they filed it. They have quoted that resolution in that, my lord.
Page 8 of my counter.
Annexure B/2. That is neither here nor there. Inner page 8, annexure B/2. Yesterday they filed, my lord. For the computerized sales.
There is nothing in this.
Only, yes, my lord.
So you will file an application by Monday.
Yes. My lord, my instruction is we will give them. My submission may be taken up for consideration.
This,
Yes,
what submission?
that we will get their NOC and allow their admission in time.
First of all, you have rejected their cases.
First of all, we have rejected the.
So this in this resolution dated 27/2024,
Yes, well.
you have mentioned that committee after threadbare discussion opined that after obtaining the NOC, there was ample time to apply for renewal of NOC.
Yes, well.
Is incorrect.
That is because in his case, it was given on 16th, 20th was the last date of this thing, renewal. That he was not been given. He has not applied for. Yes.
What is that? It was not entered in the registration of the portal, so nobody can enter.
No, portal is for admission to the students. It was 75% we have already given them.
No, for renewal. What is
Yes.
the procedure for renewal?
Renewal, once they get the renewal, they will get.
No, once they get the renewal is not the
Yes,
question.
yes.
The question is that if you grant them NOC
Yes.
and they have to apply for renewal,
Right.
then what are they required to do?
They have to make application of getting themselves in the.
Physical.
Yes.
Physical.
Yes, my lord. Physical, all on net, online. Online.
That was not on the portal. This is what he is saying.
My lord, by the time admission was over.
No. Because admission was over, they could not have done for 23-24, but they
Yes.
wanted renewal for 24-25.
That is what, because he was not applied for, we have not given, but now we will give it.
They is not that they did not apply. The question is they could not apply.
Could not apply for renewal.
All right. And they could not apply because of the lapses on your part.
Yes.
So you admit all these things. Why are you saying ample opportunity, this thing, that thing?
So let it come on Monday, I will get affidavit and I will, because the time is no more. Let's say
So
what.
there must be others also. He has come to there must be others whom he have kept pending and last moment he have disposed of.
So this is actually one of the rare enhancement. Others, no way, not connected with this.
Others also they have done same thing.
It's only enhanced.
Kept pending.
In other cases, my lord has not allowed them. Those who have come, 2, 3, 4 cases had come. My lord has said, no, you have not
That is
applied, we
not
are not taking
enhancement.
consideration.
Not applied, that depends on
Yes, ma'am.
whether they were in a position to
Correct.
apply or not.
Yes, my lord.
We have not interfered on merits. We have
Yes.
said that it is open them to approach.
Yes, ma'am.
That is premature because you were considering.
My lord, I will give an affidavit otherwise on
So
Monday,
matters are pending, I think that is.
so that my lord can give it. My lord can,
File an affidavit.
because that I will tell them to get an affidavit.
Fair to everybody, not because in front of the court.
The only thing is that where I have got the instruction, if all these NOCs, renewal NOCs given after the cut-off date, that we will allow their NOC. And we will see that they will give admission.
This is
And
a
application.
unique case actually. This is not like other matters who could not apply and they could not get it done.
Once this has been done, others will again come. That is why we want to give to everybody.
Dealing on behalf of
So you should give to everybody.
Yes, that's what.
TMET has submitted based on instructions that the Odisha Nurses and Midwives Registration Council is contemplating to consider such cases of a renewal of NOCs of nursing institutions which could not apply for a renewal because of belated grant of NOC for the academic session 2022, 2023, 2024.
24.
Semicolon for the academic session 2024-25.
25.
All right. Full stop. He has, however, submitted that in view of the guidelines, in view of the timeline fixed by this court
Yes.
by an order dated, give the details.
So that is
14,
14, 5,
14, 5, 2023,
2024.
4.
4
Subsequently
and
modified.
subsequently modified by order dated. There is a modification.
Modification
Give
order
us-
dated.
No, no, no.
Okay.
28/6/24.
Comma, the
28/6/25.
28/6/2024, the council cannot take a decision
Yes.
without
Leave
a
of.
leave of this court. Full stop. List this matter on Monday. Full stop. In the meanwhile, the council shall be at liberty to make an application to the aforesaid effect, seeking leave of this court. Comma, in peculiar facts and circumstances emerging from belated grant of NOCs for the academic session 2023 and 2023-24. So stop. List this case on Monday within first 5 cases. So stop. If we make it clear that if an application is filed by tomorrow seeking this court's leave in WPC number
139,39868 of 2020.
Check it.
the said matter shall be listed along with the present case. So the said interlocutory application shall be listed. Huh?
But that's the format of a petition that was I don't know exactly. I think, no.
Yes.
Cess admission item number 3.
May I please, your lordship? Need a 1 week time, your lordship. 1 week time, your
As
lordship.
requested. Yes.
Item number 4.
Oblige, your lordship.
May I please? Lordship, turn to page 13. Order passed by Honorable Single Judge.
Yes.
May I read? Moot question involves if a promotion of a employee can be withheld for indefinite period on the premises of pendency of a criminal proceeding over the period of decades. Fact, para 7. Facts involving the case reveals that there is a disciplinary proceeding against the petitioner besides a criminal proceeding pending in the court of JMFC Biramatrapur in GR case number 2158 of 2016 arising out of Odisha State HRPC PS case number 1 of 2017 arises 2000 allegation against the petitioner. It appears the criminal proceedings involving the petitioner are pending since 2022 and 2017 respectively. For the settled position of law, this court in disposal of the writ observes the petitioner cannot suffer for the long pendency of the criminal proceeding. It is also not known when the criminal proceeding initiated in the year 2007 will
Yes,
come.
whether notices have been issued.
Yes, madam, notice has been issued.
Someone is appearing.
Yes, madam. And I have relied on judgment of this honorable court that has been decided here, my lord.
So for writ appeal is concerned, your delay, your lordship condone the delay listed for admission.
Delay has been condoned. I have relied on judgment, my lord, that annexure 3. The matter has been set at rest by this honorable court. I relied the judgment of Janakiraman, the first leading case dealing with that seal cover procedure, and 2 judgments of this honorable court that is decided in the case of Somnath Sahu and Anil Kumar Sethi. Your Lordship has come to a conclusion that at page 36, my lord. Para 12. In the light of the above orders of the government, it is not possible for this court to sustain the impugned orders of the learned singular in the present case, directing the appellants to grant regular promotion to the respondents, even if with the caveat that such promotion would be subject to the outcome of the criminal case against such governments. The said impugned orders of the government are accordingly hereby set aside. Your Lordship has decided the issue.
Yes, what option do we have?
My lord. So far as the division bench order, at page 36, State of Odisha versus Somnath Sahu is concerned.
No, 36.
Page 36 of the
Yes.
judgment, my learned friend relying. State of Odisha versus Somnath Sahu and State of Odisha Anil Kumar Sethi. All two cases, two different division bench of this honorable court. This honorable court held that for even if departmental criminal proceeding is pending, ad hoc promotion can be granted. And
No.
this honorable court in Joseph case, without referring to the larger bench as settled law of the honorable appeals court constitutional bench and 3 judges bench, without assigning any reason, held that promotion shall not be granted. Here is question not regular promotion, ad hoc promotion should be granted. Ad hoc promotion. So Lordship kindly
Division
see,
bench says it cannot be granted.
my lord,
Division bench says it cannot be granted.
my lord, that subsequent division bench, my lord, one division bench cannot supersede another division bench as per law.
Where is that division bench?
My lord,
Where is that division bench which has been superseded by this division?
that is State of Odisha versus Somnath Sahu and State of Odisha versus Anil Kumar Sethi. Two division bench order. Here. Lordship kindly see. First is Somnath Sahu.
But they have relied on that to say that there is no right. See paragraph
My
9.
lord.
See paragraph 9.
My lord, how could the equal strength?
Okay, let us.
Therefore, Supreme Court saying, my lord.
You're not understanding what I am saying.
My lord.
They are relying on those decisions to.
Whether the coordinate bench of equal strength relying another bench will supersede the earlier division bench. That has a settled law of the Supreme Court that cannot.
Please appreciate one thing.
My lord.
That what you are submitting, we can understand.
My lord.
We may not be knowing what you are submitting, but now since you have submitted,
Your Lordship, Your Lordship,
so you are not required to repeat that.
My lord, sorry.
Okay.
This is the case of my lord, State of Odisha, Somnath Sahu and another, my lord, that is Anil Kumar.
Just a minute, let us see.
My lord.
What has been held in this case? In Somnath Sahu.
in para 7,
Para 7.
7 and 8.
7 and 8.
What has been held?
The set aside the order of the tribunal. Para 8, my lord. Opening of seal cover of direction promotion of opposite party to the rank of deputy engineer, promotion to the rank of a
Master,
deputy.
Direction is not important. The important is what law has been laid down in this case.
In the both case,
Whether the court has held that despite pendency of a criminal case, promotion can be granted. Without pendency of disciplinary proceeding, promotion can be granted despite the rules contrary to this.
In both the cases, my lord, what I humble submit, both the cases, the honorable division bench of this court relied on KV Janaki Raman case. KV Janaki Raman case held that.
Please, we have for the first time we are seeing this decision.
My lord.
You must have seen the decision more times than we have just seen the decision right now. Please point out from this decision where the division bench has held
My lord.
that pendency of a criminal case is not a bar for consideration of promotion. You show us one sentence. And then the question of judicial discipline will arise.
My lord. I'm reading, my lord, para.
You will read whole judgment. You come tomorrow, Monday. All right.
Next week.
You tell us. No,
Next.
Monday. Otherwise, we have also.
My lord, my lord.
We just go through these decisions.
I'll give note.
See, the only thing which we are required to consider is the division bench has held.
My lord.
In this case on which they are relying,
My lord.
that no employee has a right to promotion. He has a right to be considered for promotion.
Right to be considered.
In accordance with law.
My lord.
The law prohibits
My.
that if a criminal case is pending, his case cannot be considered. He cannot be promoted. Now the question is
that has been held in the Tonil City case in para 5.
that is there any decision?
My lord.
Any decision you are saying that here we have not found? Find out.
My lord.
See, the law may be harsh. The law, but we have to follow. If the law is contrary to any other provision, that can be held to be bad, set aside. But till that is valid, till that is binding
My lord.
on us also. Are we clear?
Yes, ma'am.
Yes. As requested on behalf of the Monday, 10 cases. First 10 cases. Yes.
Item 5.
Item 5, I will request that matter be taken up next week. Because I have
Next
discussed
week
with
as requested.
Item number 6.
Agent case now.
My lord, item number 5, interim order may be continued. My.
Interim order? All right. 5 continued.
6.
Then, my lord, the appellant has challenged.
Interim order. Yes, sir.
The appellant has challenged the order dated 8/12/2023 by annexure 4.
Where is that judgment?
It starts from 108 to 126. Relevant is 124 to 126.
Yes.
Lordship. Seven point 124 page number. Petitioner thereafter, in terms of the interim order passed by this court, in 28/6/25 in WPC number so and so was engaged as PET on contractual basis by the order dated 8/12/2006. In terms of the order dated 8/12/2006, so issued by the then Inspector of School, Bhadrak Circle.
What is PET? Primary
Physical education teacher.
physical education teacher.
Lordship.
Yes.
Petitioner joined as a contract PET in SN High School Josati Kira on 27/12/2006. It is found from the record that at no point of time petitioner assailed the office order dated 8/12/2006, wherein she was engaged as contractual PT in SN High School so and so. In the alternative, in terms of the order dated 8/12/2006, petitioner joined as a contractual PT in SN High School so and so on 27/12/2006.
So we are reading the whole judgment. What is
Only
the
two
point?
paragraphs, my lord. 7.1, page 126, my lord. The last page. 7.3. It is also found from the record that against the order passed by the court finally on 5/8/2011 in WPC number 9538 of 2003, the state preferred review petition in 215 of 12. The said review petition was disposed of on 14/5/2014 with the observation that since the petitioner has already been regularized with effect from 9/1/2013, right order dated 22/8/2013, no review of the order is required to be made. The petitioner has also not challenged the order dated 14/5/2014, so passed in review petition number 80. In view of such position and taking into account the fact that the petitioner was appointed as a contractual PT with effect from 28/3/2000, where she joined on 27/12/2006, this court is not inclined to allow the pair of meetings. Here, Lordship, with regard in respect to paragraph 7.3 of the judgment in the page 126, my lord, the order dated 14/5/2014, which has observed that I have not challenged. By that time, my lord, the contempt petition was filed. And in the contempt petition, the court has held that since the petitioner has joined, regularized from 2013, so the contempt is disposed of with a direction to file a fresh petition if any cause of action arises. That observation was made by the petitioner, by this honorable court. Thereafter, the petitioner has filed the writ petition, my lord, on 2012/2016. The writ petition is filed, saying that my appointment should be from 89, not in 2013. Initially, the petitioner joined my lord on 1/11/1989 as a PT.
Appointment was subject to appointment by a sponsor candidate from the district selection board. That was the terms of appointment. Thereafter, if I OJC,
OJC.
if they are allowed to continue, they are supposed to fill out according to law.
My lord. In fact, my lord, I'm sorry that the writ petition, that order has not been filed, but it has been quoted.
On what ground you are seeking your regularization with effect from 1989?
89 is the initial appointment of the petitioner. Thereafter, it was continued and she lost to different courts, my lord. And ultimately in 2000, she came to the contractual post, my lord. In 2006, it was.
No, what happened in 1989?
89, she was appointed as a teacher, my lord.
And what happened thereafter?
Thereafter, she was continued. After 2 years,
See, how can you claim you were appointed in 1989? 1989 on temporary basis. Now thereafter in 1991, someone was appointed on regular basis. And therefore you were relieved.
Relieved. Thereafter, I approached the tribunal.
Therefore,
And tribunal protected me.
Protected me, then protected, so what? There is no case.
And the Lord Single Judge has observed that the last order.
The appellant has put to challenge, in the present intra-court appeal, an order dated 8/12/2023, passed by a learned single judge of this court in WPC number 22510 of
60. 22510 2016.
Stop. The appellant in the writ petition had sought for direction. Sought for a declaration that declaration, inter alia, that yes, a declaration that the decision of the respondents to regularize the services of the petitioner as PET with effect from 9/1/2013 was illegal, and he should have been declared as a regular teacher with effect from 1/11/1989. First off, direction was also sought to the respondents to allow the appellant pay revision, pay fixation with higher scale of pay and differential amount from 1/11/1989 till date. Stop. Next, we have heard learned counsel for the appellant and learned AGA for the state. So stop. The facts, next, the facts which have been noted by the learned single judge in the impugned judgment are not in dispute. So stop. It is not the case of the appellant that the facts have not been properly incorporated in the impugned judgment. So stop. As regards the petitioner's claim, my appellant's claim of his regularization with effect from 1/11/89, it is evident from the records and the impugned judgment that the appellant was initially appointed as PET on temporary basis, where you were appointed temporary basis in Talpada Girls High School on temporary basis. by an order dated 27/10/1989. Full stop. Regular PET joined on 29/10/1991, whereafter the appellant was relieved. Full stop. It further appears that pursuant to an interim order passed by this court in OJC number 5247 of 1991, the petitioner, the appellant, was allowed to join. Full stop. Join with effect from 23/11/1992. Full stop. He was again relieved with effect from 28/3/2000. Full stop. Later, by on the strength of an interim order passed by this court on 28/6/2005 in WPC number 9538 of 2003, the appellant was engaged as PET on contractual basis by an order dated 8/12/2006. Stop. 2006, whereafter he had submitted his joining. She is joining as a contractual PET on 27/12/2006 in Essencing High School, Jasoti Cree. Stop. Learned single judge has taken note of the fact that the appellant accepted her contractual engagement after joining on 27/12/2006 in SN High School. Stop. Her services were regularized on completion of 6 years, regularized with effect from 9/1/2013 by an order dated 22/8/2013. Stop. Learned single judge has also noted that the petitioner did not raise any grievance for her relating to her regularization with effect from 1/11/1989 instead of 9/1/2013, and filed a writ petition in 2016 with a prayer to direct the respondents to regularize her services with effect from 1/11/1989. Stop. There is reference in the impugned order passed by the learned single judge to an order passed in, what is that review application number?
What is the review number?
215 of 2012. The Honorable Single Judge has referred to it in page 126 of the
No,
judge.
but who had filed?
State has.
State file.
No, but what was the order passed in this?
In the review petition, Honorable Court has said the state has submitted that in the meantime, petition was disposed of on 14/5/2014. Observing that since the petitioner has been
No, what was the
regularized.
order in the writ petition, WP? See, 9538 of 2000, sorry. WP is a 95.
Page 92.
Also, next. In any view of the matter, we are of the considered view that the applicant was not able to make out any case for her regularization with effect from 1/11/1989, 1/11/1989 in view of the admitted facts and circumstances of the case. Stop. We do not find any legal infirmity in the order passed by the learned single judge and requiring this court's interference in the present court appeal. The appeal is accordingly dismissed.
Item number 7.
Seven-year lordship notice not issued, lordship. Lord and friends appear so much, lordship.
Notice may
the
not be
respondent,
issued.
sir. I have
Pilot.
entered appearance.
Huh?
I have already entered appearance on behalf of respondent 3.
So notice may not be required to be issued. We don't know.
So
Yes.
I pray, lordship, 2 weeks after taken up, lordship, I request, lordship.
Hey,
What
I
happened?
am not
This case,
prepared, lordship.
right of the order of
I
this.
am not prepared, lordship, therefore I request 2 weeks after, lordship.
The problem is respondent is 70 years old, and only because of the record of ROR has not been prepared in her name, she is suffering a lot and unable to get her treatment. Because that is the whole problem.
no, but the judgment is in your favor.
Yes.
There is no interim order.
There is no, it's not, but the law and Tahsildar is not correcting the ROR because of the pending of the writ appeal.
Learned counsel appearing on behalf of the appellant seeks adjournment. First off, list this matter on 2 weeks. First off, we make it clear that we have not passed any interim order. And any interim order. First off, we further make it clear that the parties shall be at liberty to proceed in accordance with the order passed by the learned single judge, which is under challenge in the appeal. Right?
Item number 8.
Observe, pending of
Date same, both.
items same. Pending of writ appeal is not a bar to oblige.
Same.
Oblige me.
Item 9.
I'm sorry, my lord, on behalf of Mr. Tripathi, my lord, not keeping well. Pursuant to the earlier direction, my lord, file the affidavit, I am selecting. Let it be kept on record, my lord, and let the matter come 1 week after. I'm serving a copy to my lord senior also.
The lordship had order dated 11/7/2024 directed to file an affidavit.
That affidavit they are filing.
Yes, what do you want?
1 week after.
My friend is taking
Give
time, his senior is
I've
here.
already.
I cannot oppose this,
Uh,
but
Learned counsel appearing on behalf of the appellant intends to file an affidavit in the light of this court's order dated 11/7/2024. To stop, let the same be done. The same be filed in registry. To stop. And counsel appearing for the respondent has received a copy of the counter affidavit, of the said affidavit. To stop, as requested on behalf of the appellant, list this matter on 1 week.
Item number 10.
Yeah, please. I have challenged the judgment of Honorable Single Judge by Lord in Annexure 2, page 68. Well, this matter was mentioned before Lord's day before yesterday. For being listed, my Lord, that there was a threat for termination. And immediately on the same day, my Lord, in the evening, they issued the termination order while we were in office. So I am filing a miscase also, my Lord, seeking a stay of subject to your Lordship's consideration.
File it. File it. So when will you file?
Well, if your Lordship will see this, my Lord, about my genuineness of the claim, my Lord, in that event, my Lord, there is a purpose of making that application.
All right. Make your submissions.
My Lord, kindly come to page 82, the relevant portion of the Honorable Single Judgment. This is a case of regularization, my Lord. Initially, my Lord, in 2004, posts were created. Though there was only one post, my Lord, agency was given, my Lord, Government of India agency was given to cause recruitment. 2 persons were selected. Serial number 1 was given regular appointment, whereas we are giving, my Lord, by that agency. And we continued, my Lord. In 2015, it was in 2005. In 2015, my Lord, after 10 years, government created another 10 posts for the unit, my Lord, for Bhubaneswar. It's a Government of India dispensary. And I'm working, my Lord, as a staff nurse. So since there was a creation of another 10 posts, it was available for this unit, my Lord. Suggestion was made, and on that basis, my Lord, we have been continuing till late. Until, my Lord, the termination letter after the judgment was delivered.
Who terminated you?
By opposite party number 3. Man.
Who is opposite party number?
That is, my Lord, additional director.
So you are engaged by opposite party number 3?
Yes, sir.
You saying service provider?
No, at that time, my Lord, we were given by that is indicated, my Lord, in the order. My Lord has not indicated that at the initial entry. My Lord, can you say page 82 for a minute? Page para 14, my Lord, the facts my Lord has indicated. It's a fact that in the year 2004, opposite party number 1, my Lord, have got this.
Yes.
Decided to open new CGHS dispensary in city of Bhubaneswar, Dehradun and Ranchi by letter dated 24/2/2004. An open advertisement was issued the recruitment of paramedical staff in Odia newspaper dated 27/4/2005. Petitioner applied for the post in question pursuant to open advertisement dated 27/4/2005. On 30/4/2005, recruitment board conducted interview. Hindustan Latex Limited, HLL, Government of India is executing of Ministry of Health and Family Welfare for recruitment of paramedical staff. Petitioner selected in the selection process and joined the post in question. It is also admitted fact that the 2 out of 2 candidates, 1 candidate was selected against regular vacancy, and due to want of regular vacancy staff, the petitioner was appointed and treated as contractual. Since the initial entry of the petitioner has not been made against available sanctioned vacancy by following rules and regulations governing such entry, therefore the question of regulation service petitioner may not arise. My Lord had only lost sight of the fact that in 2015, there was post created for Bhubaneswar, and we have been continuing 2015 till date also.
There is a post created.
Yes, in 2004.
The question is whether you were appointed against that post or not.
Well,
where is that?
So it's a fact, my Lord, I was not appointed in because in 2004 only one post was available. So the person who was selected as serial number 1 of the merit list was given appointment. And though the requirement was there, we are given contractual appointment.
Contractual appointment or through service provider?
Well, by that agency, HLL, my Lord, they are saying HLL agency has given another agency, my Lord, to issue appointment letter.
Who had given you appointment letter?
Appointment letter was issued by agency of HLL, my Lord, which is a Government of India.
Therefore, you are not an employee of the government. You were employed by someone else
to
whom the contract was given. So how do you claim?
My Lord, so far as that particular portion is concerned, my Lord, it has been held, my Lord, in number of Supreme Court judgments saying that if the work is for the employer, then that has to be taken note of because the contract was whether for appointment.
We have not come across a single judgment by Supreme Court on this proposition.
Well,
There cannot be any.
well, then I'll show that.
You cannot show.
Well, I'll show.
And if you show, we will ask the other side to pay you a good amount.
Well,
See you. Therefore, we wanted to know where is your engagement met by any state agency.
No, it was not made. But the selection was made by the state agency.
Selection was made by?
State agency, madam. It's a government of India agency, madam, who has been given the duty, madam, to cause recruitment. And in that event, madam, he has directed another agency to cause that recruitment.
But is this incorrect? In the learned single judge's order, it is written in the year 2011, the company showed its unwillingness to provide service.
Yes.
Therefore, tender was invited from local company to provide services.
Well, but that there is no further selection because 2000 up to 2015, despite
on contract basis.
Yes, madam.
Yes.
But your lordship is correct because
And the authorities decided to give preference to existing staff.
Yes. And in 2015, madam, 10 regular posts were created, out of which 2 posts were staff nurse. And we have been continuing, madam, in that post also in 2015. That is why, madam, the opposite part number 3 made recommendation to the government of India, madam, saying that you regularize their services since they have completed more than 10 years of service. But just kindly see, madam, that annexure, madam. Madam, it is page 60, madam. Kindly have a glance to page 60, madam.
There is no illegality in the order. But there is no illegality, Mr.
So you are relying on that recommendation for your absorption, which was given by the additional director.
Yes.
That is all.
Yes, there are 2, but they have said they go for regular recruitment. Until that manner, there is no regular recruitment. And persons in similar capacity manner are still continuing.
Maybe. It's a question of your right to get a regular appointment. That is the question.
But if you also will put this case manner to Monday, I'll cite those 2 decisions of the Supreme Court saying, and it has been followed by the Honorable Court.
What Supreme Court is saying?
Supreme Court saying, in respect of those outsourcing agencies.
What?
That they have a right to be considered.
Right to be considered for what?
Having complete, because they are the employee,
Who is the employee?
Well, the employer master servant relationship.
For regularization, the Supreme Court has said that.
The Supreme Court has said that
the Supreme Court might have dealt that issue in respect of provident fund or something else. It's not regarding regularization.
But in this Honorable Court manner, Honorable Single Judge passed order in respect of outsourcing agency in state agency, in the state government manner. And that was also carried in the writ appeal. And writ appeal was allowed. Writ appeal was, the judgment of the Single Judge was accepted. Thereafter, 5 SLPs were taken before the Supreme Court. 3 have been dismissed on the ground of because the writ appeal was filed in 1 year delay. And the other case, other 2 cases, only on 12/7/2024, notice was issued.
All right.
I'll place those 2 before your lordship for consideration.
No, we will decide this matter.
Monday, that Supreme Court decision.
All the matters are being adjourned. Once you have this inkling that your appeal is likely to be dismissed, you are seeking adjournment.
No, not that way, because I want to show by that Supreme Court decision because I have taken
Supreme Court decision you should have brought. This matter as requested on behalf of the because we are not convinced with the submissions advanced on behalf of the appellant assailing the impugned order passed by the learned single judge. Stop. Learned counsel appearing on behalf of the appellant has however submitted that there is a direct Supreme Court's decisions on the point that the persons engaged by through outsourcing are entitled for regularization in government establishments. So stop. On his insistence, the matter is adjourned to Monday to be listed within first 10 cases for him to produce those judgments of the Supreme Court, such judgments of the Supreme Court.
Item number 11.
Facts are like this, my lord. It's a writ, my lord, filed impugning and indicating that the judgment of this honorable court was without notice to us, who are the parties relevant in 9(2) of the Orissa PWD code, my lord. And for that
Where is the order?
purpose, my lord.
Where is the order?
Yes, Annex 1, my lord. It's an ex parte order passed on the first day. Your ladyship was a party to both the orders, so therefore one of them your ladyship was a party and the other one. Your lordship, I'll take my lord's
No, you are challenging which order?
The order dated 4/3/2021.
4/3/2021 is a division bench order.
Yes.
How can it be?
I'll show my lord the judgment of that, direct judgment of the Supreme Court.
No. You are not challenging. You are seeking recall or review of
Yes,
the order.
but recall and review, my lord, has to be in a fresh writ application.
Right. That can be done.
That is.
Because you are not noticed.
It's
You
not
are
a
not
party, and
all right.
that is the only point, man. That's the
All right.
only point for consideration.
All right.
Both the parties are that, my lord. My lord, that order is passed according to it disposed of, my lord. What happens, my lord? I'll just facts are like this, my lord. The water resources, my lord, is a essential service. My lord, what happens in various places, my lord, for regulation of the water, they have these sluice gates, my lord, and various other gates which really regulate the water where it should go, and especially in the rainy season, and where it is to be stored in the catchment area and for agriculture and as well as for industry, my lord. There are, when, my lord.
Who are you?
I am a member of the Contractors Association, my lord. And I need to be, there is a mean between 10,000 and 5 lakhs, which has to be given by the superintending engineer, my lord, of that particular place. My lord, because of the emergency situation that may be necessary, my lord, they confine it to the district, that only those people will be noticed. B, a contractors association, which is a person who is a member of the contractors association alone will be noticed because of the smallness of the work and the emergent situation of the work. This, my lord, has been done away by this honorable court. The people who came in a writ application, my lord, were Orissa Young Entrepreneurs Association. It's an association. And the only association recognized under 9B is the Contractors Association. That means first you have to be a member of the Contractor Association, my lord, Orissa Contractor Association, for the purpose of getting any contract. Except, my lord, the higher contract, which has to be in global domain. All others, my lord, defined. So 9(2), my lord, which I have quoted, my lord, it is also quoted in the judgment. In the 9(2), my lord, I have quoted 5.4 grant, page 6.
Page 6 of
6 of the writ application, my lord. The first one, my lord, taking 3973, my lord. There are two matters. 3973, my lord. In the year 2015, the OPWD Code, Volume 2, Appendix 9 was amended by the state government under 9B was inserted, which read as follows. The notice inviting tender for works costing more than 10,000 and up to 5 lakhs should be circulate among the local offices. A copy of the NID should be sent to the Contractors Association and all divisions of the PWD within the district and the Superintendent Engineer's office. This, my lord, is a policy decision, and the CPWD code, OPWD code, like the CPWD code, my lord, is codified in and passed by the cabinet.
No, but how is this defined? This contractor?
Contract, yes. It is defined in section 1, my lord. Appendix 8. These rules shall be known as PWD contractors registration rules. There is a set of rules. And in the set of rules, my lord, that association is within that surrogate persons who have to become a member of the association for the purpose of getting the contracts, my lord. My lord, I am one of them, and I am a member of the association. What happens now, my lord? It is because of my lord's order, in derogation of the cabinet decision, my lord, in derogation of 9(2), my lord, what happens, although the secretary has specifically given that you will follow the PWD code letter and spirit, my lord, now the chief engineer goes ahead on the obedience of this honorable court's order, my lord, and gives to innumerable other, specifically to that young enterprises association. Young enterprises association is not a contractor per se. That can be trader, they can be anyone. And there will be hundreds and thousands of them, my lord, in Orissa, my lord, who are associations. So if each one of them I'm to be giving, my lord, in emergent work, it will be impossible to run the government, my lord. It's a policy decision that has been taken. Yes.
Right?
Yes, madam. Yes, my lord. Yes. Yes. No, my lord. Then it has to be sent to every others, my lord. That means, my lord, in that event, my lord cannot. You have to be first a contractors association member. They are not contractors association member, and they are not individuals, my lord. An association cannot be given notice because of the emergent nature of work.
No, but why your association does not have any grievance?
My lord, I am a member of the association. My lord.
You are a member.
Yes, they can. No, my lord. I as a I can.
You do appreciate that.
Yes, I can also sustain my.
You can sustain.
Yes, as well. My lord, we will array them as respondent, my lord.
You have arrayed already.
Yes, I'll ask them to come. I'll let notice go to them, my lord. I have no problem.
No. How are you so sure? You don't know. You have not met your association. Your association has not approached you.
No.
We just put a question out of curiosity.
My lord.
Why the association
is not coming forward?
Has no grievance.
No. My lord, grievance they have.
It's a body.
Yes, they should have come. I agree, my lord. Therefore, we made them as a pro forma party for the purpose of then coming, my lord. My lord, the contractor association is huge. They are hardly one of them. When they are special class contractors, super class contractors, we are puny, small industries which only concentrate on these sluice gate work.
File your affidavit.
Yes, your lordship.
And notices will have to go.
Yes.
Issue notice. AGA. So AGA accepts notice on behalf of the opposite parties number 1 to 12. So stop. 1 to 13. No, but you have not implemented the association of parties. No, young interpreter.
The persons who filed the petition are the only ones I've made a party, my lord.
No, you have to.
I will, my lord, I will, making oral prayer, my lord, and my lord may include him, include, and I'll change the cause title immediately, my lord. My lord may permit me to add the Orissa.
Counsel for the petitioners is permitted to impede what is the name? What is the name of that association?
All Odisha, my lord, all Odisha. What is the contribution name? Yes, I'll give it. We have got the, we have given the, yeah. All Odisha Contractors Association, my lord. Page 29.
All Contractors Association. All contractors.
Yes. Page 29, my lord, I've given the, yeah, also the address.
All Odisha Contractors Association through its president. Through its president or
through its president, my lord.
Through its president. Secretary.
Secretary, my lord. Yeah, secretary is the chief, that chief executive is the secretary.
As opposite party number 15. Comma, which according to senior counsel appearing on behalf of the petitioners is the association, the Contractors Association within the meaning of rule
Index Appendix 7 or the PWD Contractors Registration Rules 1967.
Appendix 7 of
8, my lord. 8 of the special provisions for restoration of work. That is, my lord, PWD Contractors Registration Rule 67.
Appendix 8. You are
8.
referring to
the Contractors Registration Rules 1967. That is the definition in the
this,
volume 2.
come again.
Volume 2, my lord, is in volume 2, my lord.
Volume 2.
Volume 2.
Appendix
Where is the
Appendix
association?
8.
Appendix 8, we are there.
1.
1. The rules shall be known as PWD Contractors Registration
No,
Rules.
but where is the association?
Association, they have to, my lord, the association has to be registered under the rules, my lord.
Where is that requirement? Where is the word association used in this PWD code, OPWD code?
Yes, yes. My lord, may kindly, the amendment has been made in 2015. Notice inviting tender for works costing from 10,000 up to so and so shall be circulated in NIT, should be sent to the Contractors Association. Contractors Association.
The Contractors Association might be 100.
No, only one, man.
Which association? This is what you want to know.
Yes, this is the Odisha Contractors, which I have given, my lord.
We don't know.
Two, my lord, may kindly see. My lord, no person shall be awarded any work except with permissible limits of the job basis under any wing of the PWD unless he has been registered as a contractor in accordance with these rules and obtained a valid certificate of registration thereof.
So which association?
My lord, the Odisha Contractors Association is the only association.
How do you define? Where has that been defined?
No, my lord.
Association registered.
No, my lord. I have to go to them, and the PWD code itself says that it has to be the Odisha. There is only one Contractors Association in Odisha.
This is your oral submission.
Yeah, my lord. Then I'll.
We don't know.
My lord, may kindly see Annexure 2.
Issue notice regard. So that counter. Seek instructions first. List this matter on 4 weeks so as to enable an AGA to seek instructions and file counter affidavit. If so, advised.
And page 19 is, my lord, I have given the registered here, but where what is falling from my lord is absolutely right. I must find that out. I bow down to what is my lord, is falling from my lord. Yes, yes. No. I will have to, I'll have to indicate that, my lord. I'll swear a better affidavit. In the meantime, my lord, I may be permitted to file a appropriate affidavit. Yes.
You have the liberty.
Yes.
Do that.
Item number 12.
11, 12 was it?
No, it's only detail page.
Deep level.
Please,
There are two cases.
Yes.
The other one, second one, yes, similar order, my lord, basing upon the first order.
Item 12.
My lord, I am appearing online for the petitioner. My lord, this is a matter which had come up last week, my lord, before your lordships, where, my lord, we had argued it at length. Your lordships were inclined to issue notice at that time, but the other side took an objection to say that the power or attorney of the person who had signed the affidavit was not on record. My lord, we have got the full trail of how the board has, my lord, approved it and how the power of attorney has been given, and we are filing this affidavit to say that, my lord, he is the person who is authorized to swear the affidavit, and he is rightly, my lord.
Have you filed or you
My
are
lord,
going?
my lord, the affidavit is available with my friend who's in court, and it's been served.
We have also served the copy on the department counsel. And because of the paucity of time, we could not bring it on record.
An additional affidavit is going to be filed on behalf of the petitioner. Upon after serving a copy thereof on London Council for the central government. First off, let it be done in course of the day.
It's already been done.
No, the filing.
Filing.
We'll do it.
Let it be done in course of the day. List this matter on when.
My lord, at your lordship's convenience.
When?
Lord, Monday?
One Monday. Monday.
Item 13.
Item 13, your lordship, the Tahsildar will be filing his reply by tomorrow, your lordship. It may be posted next week, any day next week.
But lordship, here lordship, Tahsildar lord in fact not competent. Competent the mining official. Lordship, Tahsildar, I have obtained a certain document. Let's you can, my lord friend can see. Tahsildar has already given a report. Let's you kindly see by of memo I am submitting to the mining officer. That is page 1.
No, what does he wants an affidavit to be filed.
Lordship, that's true, lordship, but Tahsil mining officer affidavit important, lordship. Tahsil, in this case, lordship, in contact with the rules, the government has framed a SOP, which is never available under rules. The SOP says, lordship, Tahsildar will furnish a litigation fee certificate. But Tahsildar is saying, I don't have that capacity, and that is the content of the rules I can supply. So, lordship, in considering the similar facts of the case, lordship given direction to the mining officer, they have considered the case of others. So, lordship, here the affidavit of the mining officer is lordship required. Tahsildar will not, because I have lordship kindly see the memo I have given.
Tahsildar is a party or not?
Tahsildar is a party, but Tahsildar, then rules lordship, Tahsildar was the competent authority. Now, lordship.
Whether the Tahsildar is a party or not?
Party lordship, he is also party.
Tahsildar also has a right to file counter affidavit.
Lordship.
Mining officer is a party or not?
My lordship.
Mining officer has also a right to file counter affidavit.
Lordship.
But the question is that all of them are officers of the state government. So there should be one counter affidavit dealing with your entire pleadings. That should be on behalf of all the state officials.
No, if that would then, if that would suffice, lordship,
Therefore, you are not required to file separate counter affidavits for all the parties.
Lordship.
So
Yes,
that affidavit should be on behalf of all of them.
Yes, your lordship. But what has arisen is, your lordship, after the amendment of the OMC rules, the auction and tender rights have gone to the mining officer and to the steel and mines department. Yes, Your Lordship. So sometimes, Your Lordship, they are authorizing the Tahsildar to file on their behalf, the collector or the Tahsildar.
This is what.
And sometimes they want an independent opinion, Your Lordship.
See,
That is true, Your Lordship. One affidavit can do.
Speaking for myself, I don't know the hierarchy of this Tahsildar and normally when the affidavits are to be filed in the High Court, that should be filed by, shown by a responsible officer.
Yes, Your Lordship.
Not below the rank of Deputy Secretary at least.
Yes.
All right. And
Yes.
that should be on behalf of all the officers.
Yes, Your Lordship.
Separate
Yes, Your
affidavits
Lordship.
are not, so we will not indicate as to who will swear the affidavit. It is up to you who will, we are concerned with the affidavit which you are going to file on behalf of all the opposite parties.
Lordship, 2 weeks' time may be given, then I will ensure that one single affidavit is filed.
2 weeks time, 2 weeks further time is allowed for the opposite parties to, for an AGA to file a counter affidavit on behalf of the state opposite parties.
Lordship. 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 That is my grievance, Lordship, because Tahsildar cannot answer. Tahsildar already answered by you of this, Lordship.
Item 14.
Grateful, Lordship.
My lord, Mr. Swai is ill, my lord.
Who is ill?
Mr. Swai is ill, my lord. 2 weeks time may be granted, my lord. Case payment. Kunal Kumar. Yes.
As requested. So, 1 week.
Item 15.
PK Mahapatra.
Item number 15.
May I please, Lordship, that the petitioner who was a tenderer in respect of a construction of bridge has filed this application challenging the cancellation of the tender. My lord, the fact of the case is like this, my lord. The Lordship may kindly see Annexure 1. My lord, by this tender call notice was issued in construction of 3 bridges. Page 16, your Lordship may kindly see 3 bridges, my lord. And the tender paper consists of technical bid and financial bid. I am concerned with item number 2. I, along with another person, filed the tender papers. Then the technical bid was opened by the Annexure 2. In that opening of the technical bid by the committee, it was found the other person is disqualified and I qualified. Then my financial bid was opened by the Annexure 3. It was found that is in excess of 1.99% than the estimated value. Then after this by the Annexure 4, I was asked at page 65 to reduce the excess amount by negotiation. Then I put my valuation at 1.5% in excess. Thereafter, thereafter I was once again asked to reduce the valuation on negotiation. Negotiation went on. Thereafter, my lord, while the negotiation was going on, all in a sudden by the Annexure 7, my lord, the tender is cancelled because it 1% excess than the estimated value. Thereafter, my lord, after knowing the same, after completion of negotiation by the Annexure 9, I filed less than 3.10% of the estimated value.
After cancellation?
My lord, cancellation is by the government. But here, since it is 7 to 10 crores, it is the engineer in chief engineer is the authority to approve. But here, the government has cancelled it as because it is 1% excess. But fact remains, my lord, why, my lord, I have filed an additional affidavit that is not on list, but it is common record, my lord. For similar work, item number 3, my lord, similar things happened. There, the contractor who was found qualified in the technical bid submitted his tender, submitted his financial bid 1.5% excess.
But that has been accepted, my lord. Your lordship may kindly see annexure 12, my lord, to my
Where
additional.
is the cancellation order?
My lord, cancellation order is annexure 7, my lord, page 68. Because it's 1% excess.
Oh, my lord, this is a single bid, my lord. Single bid, my lord. Only one person is there. At the first instance. No, single bid, my lord, cannot be granted at the first
But
instance.
2 persons applied, filed the tender
2
paper.
persons applied, one is rejected, technical was rejected.
Your lordship may kindly see for a moment annexure 11 and 12. Similar circumstances, my lord. It has been accepted in excess.
Now, whether in that case also it was a case of single bidder.
My lord, yes. Same. 2 bidders. One is disqualified. The other was found suitable. Report I have also submitted, my lord. Annexure 12. Your lordship may kindly see the affidavit. Additional affidavit I have filed.
It is
I have
stated
not
by
received the
counsel
additional
writing
affidavit.
on
Each
behalf of
copy
the
is copy
petitioner.
nine.
An additional affidavit has been filed, which affidavit is not there on record. Let's this matter on Monday.
My
With
lord.
this additional affidavit.
My lord.
But which is the provision which requires that in case of single bid, the tender shall be cancelled?
My lord.
Where is that?
My lord, status annexure 7, my lord.
Annexure 7.
My lord.
This is the provision.
OPW code, my lord. I will. 3.1.17. I'll go through, my lord, on the Monday. Public.
So that is humbly submitted that the total number of contempt cases are pending due to non-disposal representation as on 24/6/2024 were 5,707 in all 40 departments. Few departments were able to successfully achieve 100% disposal rate, while a significant number of departments reduced the majority of their pending cases, almost achieving 90% of disposal rate. Currently, as on 22/7/2024, out of 5,707 cases, 3,655 cases have been disposed of by speaking order, and writ appeals SLP have been filed in 740 cases, as mentioned in the table minutes I've given. And the details of the disposal I have got in a sheet minutes. I'll provide it to my postmaster so that he can verify it and get it listed chronologically so that those can be disposed of. And so far, balance 1,300 cases are pending. But we have prayed for the some time to pass speaking order, because their direction is to issue notice to the parties. So it will take some time. Here, department wise, I've given the disposals. And in the present case, the order has been complied with. Amount has been paid. It's a R&R policy benefit that has also been given.
Do you have a soft copy of this? Soft copy of the.
I can get it.
Must be having. I'll incorporate the entire.
But we e-filed it. I have already e-filed it yesterday. But if you also want, I will give the soft copy to
What we want, Mr. Samandra, that we will quote the entire affidavit in our order.
Right.
All right.
Right.
Whatever has been stated.
Yeah.
And
I will get it. I understand. For that purpose, I will get the soft copy so that I can give it to the court martial. And this is department-wise disposal. And I've given the case numbers also so that it can be listed by the register chronological, can be disposed of.
Yeah, this is, we are very happy.
Yes, sir.
We are very happy
Okay.
for the efforts made by you and the
No, yes.
government also.
Yes, sir.
Uh, concerned about the pendency, huge pendency of contempt cases before this court, particularly relating to particularly arising out of such orders passed by this court, whereby the officials of the state of Odisha were directed to dispose of various representations filed by the respective petitioners. This court had required personal appearance of the Chief Secretary of the state of Odisha online by an order dated 18/6/2024. Stop. The matter was taken up on 26/2024 when the following order was passed. In response to the said order of this court dated 26/2024, an affidavit has been filed, compliance affidavit has been filed, shown by the additional secretary,
Additional Chief Secretary,
additional chief secretary,
GA and PG Department, General Administration and
General
Personal.
Administration and Public Grievance Department today. Full stop. For future reference, we deem it appropriate to reproduce the entire contents of the said affidavit in the present order, which read thus. Paragraph 5 to end. Full stop. Mr. Samantray, learned AGA, has furnished to this court lists of the cases, contempt matters in which the orders for disposal of representations have been complied with, which is taken on record. So stop. This court will consider listing such matters for final disposal after due notice to the parties concerned in advance. So stop. What was this about, this contempt matter?
This contempt matter order has been completed. There was a direction for payment. Payment has been made.
There is no whisper in the compliance affidavit that my case has been complied. There is not a single line, my lord.
No, let me see his order. Where is your order? Where is the order passed in your case?
No, I think my learned senior is holding that affidavit filed by the additional chief secretary. The contempt was filed the affidavit.
Dispose of my representation before pending.
So your representation has been disposed of.
My lord, there is no whisper in this compliance affidavit. There is no whisper.
Please.
No, I have given copies of that affidavit. I have given to lordship. The compliance affidavit is with me because my friend was not there. I have not given to him.
No, I have
amount is all
just now.
I said no. I wouldn't go. But
Oh, sorry, sir.
I am giving another affidavit. My friend is in a hurry. I don't know why. There 47,000 has already been paid. Even though there was a direction to dispose the representation, he was found eligible to get 47,000 RR policy. That has already been paid and he has received. Lordship, can you look at this? I have given these copies. Vouchers are also there with regard to that payment.
This affidavit you have filed in the PIL or in this?
No, this is a contempt, present contempt where all.
This petition order. I'm talking about this affidavit.
Affidavit in this contempt number 3954.
His order. No. Pass in both cases. As regards the particular grievance of the petitioner of CONTC number 3954 of 2024, a separate affidavit has been filed, copy of which has been served on learned counsel for the petitioner, from which it transpires that this court's order has been complied with. Stop.
My lord,
CONTC number 3954 of 2024 stands disposed of accordingly. Stop. The petitioner shall be at liberty to seek redressal of his remaining grievances before appropriate forum in accordance with law. Stop. List WPC number 28053 of 2023 on 6 weeks.
In that WPC, today I filed an affidavit by the chief secretary, wherein lordship directed to file the litigation policy on the things. That affidavit may also be called for along that record.
All right. The affidavit, where have you filed?
Today, I have already filed in the e-filing.
Physical copy.
The hard copies I have got.
We have been informed by learned AGA that an affidavit has been filed in WPC number 28053 of 2023, bringing on record the litigation policy of the estate.
Yes, sir.
And what? Only litigation policy.
And the other things that the lordship pass and order, those things also I have mentioned here.
We shall
Meetings of
consider
different meetings and all.
we shall consider the said affidavit on the next date. which is taken on record. इसको scan करवा देना. Disposed of matter. And the contempt.
A copy of the order.
Copy of the order you will not get.
No, not, I'm not asking for free copy.
Ah.
Certified copy.
No, so lordship, in that affidavit, I had prayed for further 2 months' time to dispose of rest 1,312 cases.
6 weeks. 6 weeks we have given. Just a minute. We record our appreciation for the sincere efforts made by the state officials in expediting disposal of representations which were pending since long, because of which huge number of contempt cases are pending in this court. First off, we also record our appreciation for the efforts spent by Mr. L. Samantrayal and AGA. And yes,
The additional chief secretary was interested to be in VC, but because today the budget is being presented, he is the secretary of parliamentary affairs, so he
All
could
right.
not join your lordship.
all right.
So he had said that to.
No, they have done a wonderful job.
Item number 16.
May I please, Your Lordship? A tender was floated by opposite party number 2 for reconstruction of HL Major Bridge across river.
Just a minute, just a minute. This is 17327.
17327 of 2025.
Yes, please.
At page 28, annexure 2, Your Lordships will get the tender which was floated by opposite party number 2.
Yeah.
Now, at page 138, Your Lordships will find that the petitioner participated in the tender by furnishing a bank guarantee for rupees 64.84 lakhs.
Annexure?
Annexure 5, my lords.
Yes.
Huh? 158. They have acknowledged bank guarantee. That's at page 138.
Yes.
Let's thereafter, my lords, while the tender was pending consideration, the petitioner was learned that he has been branded as a non-performer in respect of another contract. So, my lords, immediately he made a letter to the authorities saying that kindly allow me to withdraw my bid because I will suffer, otherwise I will suffer disqualification. So allow me to withdraw my bid. Be that as it may, they issued a show cause notice to the petitioner. That show cause notice is annexure 8 at page 157. In the third paragraph of that notice, in the second paragraph, they said that it has come, as your lordships got that page, page 157. It has come to the notice of the undersigned that you have been declared as non-performer by NHIDCL while letter dated so and so, following standard operating procedure in accordance with MOT letter dated 6/10/21. It has also been mentioned in the aforesaid letter that upon declaration of non-performer, the bidder, Brijesh Agarwal, as per para 8 of MOT circular, will not be able to participate in any bid with MOT or its executing agencies until the contractor is removed from the list of non-performer for debarment persists or debarment persists. Despite the above fact, the validity of the said order of NHIDCL is on bid submission date. You have participated in the instant tender and also you have not mentioned anything regarding the debarment declaration as non-performer in the letter comprising technical bid and appendix so and so to in the RPF document, in the bid document submitted by you. Hence, this comes under fraudulent practice, misrepresentation, omission of facts, suppression facts, disclosure of incomplete facts. This was the allegation made. I immediately responded thereto at page 159. Second para. We have not done any act that comes under the fraudulent practice, misrepresentation, omission of facts, suppression of facts, disclosure of incomplete facts. We have not received the NHIDCL letter dated 24/7 through any mode, that is by hand or by post or by email, until 6th November 2023, 12 p.m. And until today, that is 9/1/24, we have not received the same.
All right.
Then, my lords, I gave this. They responded thereto, which is at page, the impugned order, which is at page 163. No, sorry, my lords, not 163.
173. No.
That's at 179.
Yes.
Now, if your lordships will see, para 7, they have taken note of my reply that Brijesh Agarwal replied by his letter dated so-and-so and they had not received the NHIDCL letter dated so-and-so. That is the order of declaration of non-performer through any means, including but not limited to hand delivery, postal service or electronic mail. Further, the bidder has stated that he did not know about the declaration of non-performer by NHIDCL at the time of bid submission. However, he knew from the website of NHIDCL during the 3rd week of December 2023. They have taken note. Thereafter, my lords, at para 10, that the regional office Mor Bhubaneswar White letter dated so-and-so was communicated to seek the following information from NHIDCL on the declaration of Brijesh Agarwal as non-performer for taking appropriate action on the subject tender matter. A, date of completion of work by the EPC contractor Brijesh Agarwal, as he has been declared as non-performer for a period till the project is completed. B, that the EPC contractor has been removed from the list of non-performer, or if the department still persists. So the moot question that was required to be ascertained, whether the order has been communicated to me, was never put forth to NHIDCL. As a result, the allegation of suppression, my lords, on the basis of which they have cancelled my bid and now seeking to forfeit my security deposit, is based on absolute non-consideration of the case which I have put forth.
Yes. File your affidavit.
I'm appearing for the Union of India.
Union of India. And this was the tender notice was issued by whom?
By opposite party number 2, that's the state.
He's a representative of India.
The representative of Union of India.
And who appears for that company?
Company, my lords, national is a pro forma opposite party because I will take out notice on them also because they are the ones who say that I'm a non-performer. I'll take out notice.
Not only that, the moot question is as to
whether they have communicated the order to me. Absolutely. But I bow down to that. I'll take out notice on 3 and 4. 1 and 2, I think my learned friend will
accepts for the estate.
No, state is not there, Manoj. State is there. Sorry, Manoj.
They refused to copy.
They did not accept, Manoj. They said that notices.
State is not there.
There is National Highways Odisha. National Highways.
State. PWD.
No, National Highways, Achha. You have not described.
Page 29 of the commercial.
You better you correct your.
No, my lords, page 29, my lords. The entire,
Where is the?
your lordship sees at page 29, the chief engineer.
No.
Yes.
NH,
National highways. Lord's like-
HS is highways. National Highways, Odisha.
Every state has one department which executes more work for the state.
Well,
But it is controlled by the state. No, this will
my
be
lords, what I am informed is that every state.
This is C. Government of Odisha will have to be implemented.
Yes, no, he's the officer concerned. He's the government of Orissa officer
But you
concerned.
have not implemented.
No, he's opposite party number 2. He's the government of Orissa officer who is in charge of national, because this national highways.
How can you make this submission? If any official of Odisha is to be has been implemented as a party,
Yes, sir.
the state of Odisha should be implemented as a party.
I'll meet. Your lordship may accept my oral prayer.
The officer has no locus.
Your lordship may accept my oral prayer. I will implead the state of Orissa represented through.
Correct the.
The chief engineer.
It's through the chief engineer. Now,
Let this matter come after 1 week. In the meanwhile, we will permit you to amend your first title for the purpose of impleading because that is absolutely not acceptable.
well, it's at page 33, if your lordship sees, that is the way, your lordship kindly sees, page 33. This is the Odisha government website. Your lordship sees page 33, my lords.
Odisha government, see, you have grievance against Odisha government. You have a grievance against Odisha government because the order has been passed by an official of the Odisha government. So unless you implead, that is the law which has been laid down by Supreme Court.
I will do that. I'll do that.
All right.
I will. I bow down, completely bow down to that. I'll do that.
So
But that's the way they describe themselves. Page 33, if your lordship sees.
No question. The moment you see that some illegal, according to you, some illegal order has been passed by an officer of the Odisha government, you will have to implead Odisha government as a party. Because no, that cannot be done. See, come to an extra. No.
Through the state.
Not only that, come to an extra rate. 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 This 8. It is government of Odisha.
Yes, madam. That's the impugn order. Yeah, I've seen that. I've seen that. I will implead the government of Orissa, state of Orissa as a party. Your lordship may accept my oral prayer. I'll amend the cause title.
Do it.
I'll do it now. I'll do it.
Not today. Let it come. We will take up. We assure you that we will take up your matter. We understand the urgency of the.
My only anxiety is that let my security not be encashed.
We understand.
It is valid till that's the day page. I'll just say. In fact, page
It's very 1/8/2024.
1/8/2024.
Page 135. We will extend it, let them not.
2024.
Yes.
24.
So we can take up the matter on Monday. All right.
Maybe they have already sent a letter. So if the bank responds and encashes, then my lords, I'll be nowhere. And it's a big amount, my lords.
Discuss matter on Monday, so as to enable and counsel for the petitioner to correct the cause title of the writ petition and file a fresh cause title. Post hoc. We observe that in the meanwhile, the parties shall maintain status quo. As regards your
The bank guarantee, annexure 14 months. With
the bank guarantee furnished by the petitioner. Will that do?
Okay. Okay. It is,
Concerned bank guarantee.
bank guarantee number is
Concerned bank.
public.
Item number 17.
If it may please the court, your lordship. Your lordship, this is a tender matter where despite the petitioner being declared as L1, has not been issued the work order for last 1.5 years, your lordship.
So where is the law
Your lordship,
that L1 should be given work?
your lordship, the difficulty is now he has completed 30% of the work. But since the work order has not been issued, his bills are not being cleared, your lordship.
So why did you start working?
Your lordship, on the insistence of the opposite party number 2,
And
Yes, sir.
recover from him.
lordship,
Can be done. Without work order,
lordship.
you took
But
out the
already
work.
declared as L1, your lordship,
So what?
your lordship.
So what? You should have waited for the work order. Yes, file your affidavit. Sometimes it happens that at your instance, this thing, after having, and only a formal work order may be required to be issued. You don't know.
Your lordship, only to process the bills, your lordship. Your lordship,
2022-23.
your lordship.
What work order will you get now in 25?
The difficulty lies with, he has already started the work on the insistence and yes, no work order is there, so
There
the
has
bills are
been no
not.
inspection report also to that effect. I will seek instructions, Your Lordship, as to it.
8 weeks' time is allowed for the opposite parties to seek instruction. Allowed to learn the AGA to seek instructions and file counter affidavit on behalf of the opposite parties, if so advised. Yes.
Item 18.
Oblige.
May I please, Your Lords? Madam, this matter relates to renewal of a NOC.
Item 18 may be taken up on 30th, which has been fixed to for disposal. That
Along
is
with item
similar to that.
58, right? Along with item 58, madam.
Today's list, item 58, it was fixed to 30th.
WPC, that is WPC 15,883 of 24, madam.
List this matter on date constant 30th July 37, 2024. Along with
WPC 15,883 of 24.
and batch. And what about 58, item number 58?
That is adjourned to.
That is, that is.
September.
52 and 58.
Item 19.
Wait, please wait. In this case, my last friend wanted to show the order of the Honorable Supreme Court staying the further proceeding of these cases, Lords. So Lords, you wanted him, he can give that copy of the order.
Which order is under challenge there in
My lord. Lords, I filed that review of the orders passed both in Lords, OJC number 7386 of 1999 and WPC number 133 of 2005, Lords.
No, in this case, which order is under challenge?
It's 9/12. 12.
12 times 7. 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 12 ti
Mr. Patnaik,
Yes, ma'am.
the first order you are given 24/7/2023.
Yes, ma'am.
The interim order is extended, so there must be an earlier order.
My lord, here, my lord, interim order staying, here, my lord, delay, issue notice by speed post, ma'am. Interim order staying for the proceeding, IA number 12 and 14 of such and such shall continue till next date of hearing, ma'am.
The first interim order.
My lord, this is the first interim.
Discuss matter. Our attention has been drawn by one counsel appearing on behalf of the petitioner,
Opposite party.
on behalf of opposite party number.
Because in this OJC number 7386, he is the petitioner.
Both the petition.
But the review petition, he is the opposite party. Where the two matters are there.
Those two IA.
Because it relates to IA, Lossi may say petitioner, both the cases, both the writs. He is the petitioner.
Just tell him our attention has been drawn. The petitioners to the order passed by the Supreme Court dated yesterday. No,
No,
before
last order is 15/4 minutes,
15/4.
whereby it has been posted to 10/9.
2024. In special leave to appeal bracketed C number 16468 hyphen. Not diary. Hyphen 16469. I know 2023. So from the said order and the previous orders passed in the said case by the Supreme Court. In view of the said order and previous orders passed by the Supreme Court in the said case, list this matter. These matters are adjourned to be listed after disposal of funds. This October. These matters on October. 8 weeks.
It's 1990. October 2nd, September, October. Item 20.
Your Lordship, in item number 20, Your Lordship, I am for the respondent, Your Lordship. I need to file objection to the condonation of delay application, Your Lordship.
What is the delay?
175 days.
File objection, but why
Ye-
didn't you file? When did you receive notice?
Pardon, Your Lordship.
When did you receive notice?
No, I have received the copy, Your Lordship, on the last date occasion, Your Lordship.
As requested on behalf of the
Lordship,
respondents for filing an objection to the application seeking condonation of delay. List this matter on when?
3 weeks time may be given, Your
3
Lordship.
weeks.
Lordship, as per the last order, I have received the copy from the government, Your Lordship, on the last occasion, Your Lordship.
Item 21.
Obliged, Lordship.
I am for the respondent, my lord. Pursuant to last order dated 4/7/2024, I have appeared. Sorry, I have appeared for 273 respondents out of 1945 private respondents. We have received instructions from more other respondents. So I pray 3 weeks time to file fresh other vakalat.
But this is unending.
They are poor persons.
After receiving instructions from 899 persons, you may say that I'm yet to receive
They are coming,
instructions from one of them.
they are poor old persons,
We can-
retired persons. So 2 weeks time at least, I pray to give so that I can.
See, you will have to collect wakalatnamas from them.
They are staying different parts of Odisha, my lord, and they are very poor persons, my lord. That is the difficulty. And they have telephoned me and they will come within 1 week, 1 or 2 weeks, my lord.
As requested on behalf of the Mr. So-and-so submits that he has instructions to appear on behalf of such respondents also who have not entered appearance so far. So stop. He is expecting to receive duly executed wakalatnama in his favor shortly. So stop. List this matter, these matters on how much time?
3 weeks time, man.
3 weeks.
You already filed for how many?
My lord.
This- these
Al-
matters-
Already appeared for 273 persons.
There's only
Five.
one case, no?
The one case. The
Item 22.
condonation of delay petition may be solved, not solved.
So,
Okay.
Item no 22.
Here there is a delay of 183 days, but the notice has returned with valid service. The Lordship has taken note of that on 18/7/2024, the last order, but nobody has entered appearance for the opposite parties.
All we are condoning the bill.
22. Yes, my lord. On 18/7, your Lordship has taken note of that. 18/7, the last order.
After flagging service on the respondent, 18/7/2024, when the matter was taken up, not had appeared for the respondent, the matter was for this. When the recipient reported that the counsel is appeared on behalf of the respondent of the party. Passing the explanation given for the in the explanation which has been given for the delay in filing the return comma which satisfies the delay in filing the comma is allowed at this point. It's the case of admission on first August 2024. 8th August. connected matters there?
That batch of Sarat Chandra Parida case. Today's five. Today's item 5, it was there.
Item 23.
23, my learned friend has also appeared. This matter relates to that Sartapada pension during that block grant period. Your Lordship may take this matter along with item 5. Item 5 is the lead matter that will be decided. All the matters can be decided. 197, my lord. That item 5, the 3 matters are there.
What is the delay?
My lord, admitted delay more than 300 days.
Delay is more than 300 days in all 3 matters.
So we'll consider. At the time of admission, we will consider.
Right.
WA number 197 of 2024, the last item, that is
WA number?
197 of 2024. That in item 5, 3 matters are there. One, last matter is 197.
Item 24.
Please, my lord. My lord, here, my prayer is for my grievance petition, which is also directed by the secretary to the Tahsildar to dispose of that because that the school premises has been also spoiled by digging the soil as well as also destroying the trees. By the annex of 3, my grievance petition is there. Let the direction be issued to dispose of the grievance petition.
The secretary has directed.
And annexer 3 under secretary to government. Again? 2017, yes. And the Tahsildar has done nothing. A fresh direction we issued also. My lord. Yes, the grievance petition of the villagers. Matter is also, my lord, sheet pending it is 2023. So grievance is enclosing here with a copy of the grievance petition dated 27/11/2017. See, Alok Samantaraya, chairman. That is grievance that the school premises has been spoiled. They are also digging this school premises by taking out this earth and also cutting the trees. And the one road has also entered into the school premises. That is our grievance.
That was 7 years back. Your prayer is not to allow any approaching road with the school fee.
They have not done anything as it. Only they have also cutting the trees and also taken out the earth, and they have done nothing. So only let it be inquired upon. Tahsildar to inquire the matter, submit a report.
Take your affidavit.
Hello.
If the allegations are correct, then
No.
this writ petition has been filed in the nature of public interest litigation, raising certain grievances about the condition of Bakugram Primary School, Bilanga under Nimapada Education District. Stop. A counter affidavit be filed on behalf of filed by the no educations by the secretary, no chief engineer, no collector. Who should file affidavit? by the collector Puri.
Opposite party number 4, my.
Yes, by the collector Puri, directed opposite party number 4, dealing with the allegations made in the writ application. Time here. Does this matter on 6 weeks for the said purpose? So this will be better than disposal of your representation. So they shall consider your case while filing your counter affidavit. Filing the, we will see.
All right, ma'am. I'll remove the defect within a week.
Oh, defects aren't good. No, first remove the defects. Sorry. Recall that.
Remove within 1 week or 2 weeks, then after they will find out.
Within a week, I will.
Item 25.
Item 25. There is a delay of 113 days. But if your lordship remembers that case of 2 education district application was made for, so similar case your lordship has dismissed. State writ appeal. Yes. That same order has to be passed, same district.
No, yeah, but similar case has been dismissed, a similar point of. Yes, yes.
That is WA 206 of 2024. 9th July 2024.
9/7. That is
the order has not been uploaded, so I could not produce the order.
When was the order passed?
Order 9th July 2024. Today I checked up, the order has not been uploaded.
that is the. जो सेटा देगी अपलोड है नहीं किंतु सेटा डिसमिस्ड पर
Yes.
Yes.
Item 26.
This is that matter where the Raulkela Development Authority had granted a lease in favor of a person who died. Subsequently, the widow wanted to alienate and sought for permission from the Raulkela Development Authority. And Raulkela Development Authority wanted that no objection from other legal heirs. But this present appellant had made objection, but that was under challenge. And the Honorable Single Judge has held that no, it is not required. He can alienate. That is under challenge, that without a deed of relinquishment from the side of other legal heirs who have succeeded to the property simultaneously.
Yes. So what we intend to do in this case is, we have no other option but to set aside the order of the learned single judge. If there is any dispute, that will have to be decided by the civil court.
This your lordship had suggested the other day.
We don't have any other option.
As your lordship, please.
I'll just clarify one thing. I'm appearing for the mother respondent.
As regards title, yes.
I'm appearing for the mother respondent, my lord.
Yes.
Number 1. I had filed also a written note chat. I only beg to point out one thing. The initial grant was only an allotment letter, not a lease as mentioned by the appellant in the dead chat. That much I beg to clarify. And I have also annexed the allotment.
Mr. Unless we hold title in your favor, the order of the learned single judge cannot be sustained. Learned single judge has held title in your favor. that is, in our opinion, not permissible in a writ proceeding. All right. So
title is-
that dispute, unless you title is declared, you cannot alienate. And they are not the other siblings, other heirs, they are not implemented parties in the writ proceeding. Why?
May I just clarify one thing?
What?
My lord, the other heirs have not been impeded for the reason nobody else except this present appellant raised any
We
objection.
don't know. We don't know what happened.
No, preceding this also they had filed
Oh
affidavits.
no, sorry.
But they had filed affidavits for the Rautala Development Authority when the lease was made in favor of the respondent number 1 after the death of the husband.
You should have fairly implemented them also as parties in the writ proceeding. You did not do that.
They don't have objection even as
And in their absence, how can you say that the title could have been declared?
No, they have not. The
That cannot be done.
Honorable Single Judge has not declared title. What he has done, the refusal of permission to transfer has been held to be bad.
Then, Mr. Mishra, you have not read the judgment.
But I have read the judgment. My lord, Your Lordship, what I humbly beg to submit, lease deed is in existence. That has not been questioned by anyone in any competent forum.
We cannot go into that.
So lease deed as on today stands valid.
Huh?
And
No chance.
one more.
Mr. Das has no objection if the lease deed is there. He is objecting to the transfer, right? He doesn't mind. He is not objecting to the lease deed.
Yes.
He is objecting to the transfer.
What I humbly beg to submit, lease deed on the face of it, he cannot object to the transfer. That's what I beg.
Yes, that is your submission. But this is his submission. Lease deed, he has no objection. He only objects to the transfer.
And one more thing I was clarifying, that initial allotment in favor of the predecessor was an allotment letter, not a lease deed.
All right.
That I have filed along with my written note, which was obtained under RTA.
Where is that written note? It is not there. Yes, I have got.
You are again relying on information received by
Actually, written note. There's no written note.
See, this is the observation of the learned single judge.
Right.
And single judge has observed that no relinquishment deed or so and so is necessary for according permission to the petitioner for the third party transfer of the case house, as none of legal heirs except the petitioner, none of legal heirs, other heirs were not parties, has any right, title or interest over the same house after lease cum sale deed under annexure 2 was executed. So lease title not in favor of any person other than the respondent. So this cannot be done by the High Court in writ jurisdiction. This is what we are going to hold. Yes.
He only given an observation while deciding the issue with regard to permission for
That
sale.
we have refrained from addressing the issues of succession, inheritance, so that no party stands prejudiced if any suit is filed. This is our observation.
But
With the, yes.
Lordship got my note, my lord. I had filed my. I think my lord Justice Rotho was pointing out that the note is not available on record.
What do you want to point out from your note?
Only that initial was not a lease deed; it was an allotment letter.
All
That-
right. Well, While finalizing the draft, we shall take into account that also.
My lord.
When did
That
you
was
file?
filed
But not scanned. no?
When did you file?
on the last occasion when the matter was heard. I have given a copy to my
That we have taken note of. Yes.
Mr. Das also. I have given a copy to him.
Not scanning the documents filed in court.
Item 27.
Obliged.
Next one.
The regional manager has come.
David Padmal, I was appealing for S1 number 5, Development Authority.
Yes.
Anil, the regional manager has come.
Personal appearance had been.
Yes, who is for the nominee? Who is the nominee?
Nominee is that,
Have you informed her about her rights? Yes. She is the nominee? Yes. So is he ready to sign papers?
she or he, Rohit? He. So who's the lady?
His wife.
Why she has come?
Just like introvert.
Huh?
He's an introvert.
Right.
So wife, all right.
After receiving the notice, your lordship, he has requested the petitioner time and again, but petitioner not responded.
What will petitioner do? He has to sign.
Yes.
So this will be done today.
And
When will that be done? Well, you are the regional manager.
yes, sir.
Can you understand the plight of this old woman? That ought to have been resolved at the level of the branch manager. And see the first affidavit which was filed by the branch manager. That created the entire confusion, filing of review application and everything. So do it and get it done today itself or latest by tomorrow.
And please,
Whatever formalities are to be done, please get it done today. Therefore, the nominee is here. All right.
Lord, in this case, nominee has to get 30% amount and rest 70% amount.
How 30%? You know, where is the law?
That is order in the court.
Oh, that code will, that matter is there.
that is there in the order. Which order?
The order of the Honorable Single Judgment.
No.
Let us show us the order.
There is no such.
That is in also in the,
Please show us the order.
that is in the affidavit. 1/3/24, man. That in the affidavit it was reflected.
Order dated.
Order dated.
The writ petition is here. So we'll see what's the order. Order passed in the review or the writ petition?
No, in the interim application, in the review application 198 of 23, man.
Not here.
Do you have a copy?
Your lordship, 1/3/2024, your lordship.
No, is it part of the writ appeal? Dele se order tha?
The law.
What's the amount?
We cannot.
Kept in fixed deposit?
Total amount
Yes.
with interest 9,
Interest.
5 lakhs.
5 lakhs the fixed deposit.
So what is this, that 1,50,000 will be
Yes.
given to?
1,50,000, 30% of the amount.
That was consent of both parties.
No, it is not my consent. I have not given any consent.
In writing. The order says Mr. Naik submits the matter may be disposed of as his client is willing for the bank to disperse 1,50,000 from the deposit and its accruals to Mr. Mahanta's client. Balance of the deposit and accruals to be dispersed by the bank to his client.
And when the single judge asked me to how much you will pay, I denied. But the single judge told that it cannot be disposed of. So that some money was proposed by the single bench. Single bench decided to pay 1.5.
What is the total amount now?
Total amount 9 lakhs.
So 5
9
lakhs.
lakhs 46,350.
What is the amount?
9,46,350.
9,46,350. So this amount is to be paid to the heirs,
Legal heir.
legal heirs.
Mr. Mishra, last date also you did not bring to our notice this order. It is only when we have directed for the personal appearance that I have directed.
That is in
Had you brought to our notice that Mr. Naik has agreed for payment of 1,50,000?
Yes,
This order we are seeing.
in our affidavit.
Which affidavit?
The
Yes, after we
affidavit by the
directed for
regional
them to
man.
file an affidavit, yes.
Yes,
You have
regional.
not been assisting the court properly.
Well,
First
regional-
of all, that wrong affidavit with wrong information for which all that thing started review and this person had to agree to pay 1,50,000 to the nominee.
Beg pardon, my lord.
If you are handling the case of the bank, you should be a little more careful.
My lord, beg pardon, my lord. In the affidavit, you have stated that the regional
Exactly, you keep insisting that without admitting what you have done.
because
Unnecessarily on account of the wrong affidavit filed by the bank, 2 review applications had to be filed, number of IAs and then this writ appeal
they have filed.
and personal appearance of the officers.
They have filed there.
Again,
And they have filed miscellaneous applications.
again, because of this review order, otherwise that order was in the favor of the petitioner to release the money. You have filed the review and got the order changed.
Second review he has filed.
He will file because he is for the petitioner, he is aggrieved. You should be more careful. This is the High Court. You can't file whatever affidavit you want. And their officers also, they will get into trouble for giving false affidavit before this court. That is why we have directed for their personal appearance. That how could that affidavit be filed in this court, giving wrong information? The petitioner is a widow lady. She must be semi-literate. Her mistake can be excused, but when you are doing it for the officers, you have to be careful.
My lord, another grievance, that is opposite party number 2 and 3, they driven out that lady from their in-laws house.
So this you have filed a civil suit for injunction or what?
No,
Then?
no. She has instructed me that you place this matter, my grievance, that nothing is given by the opposite party number 2 and 3 who have possessed the landed property forcibly. Nothing is given to the lady.
No, we are dealing with a piquant situation. We are dealing with you, we are dealing with them, and we are dealing with him. This is the observation which we had made earlier also.
False affidavits are given in 3 occasions. First in writ application.
Mr. Counsel, you please keep your mouth shut for the reason that we have entertained this application, though we ought not to have entertained. But because of the incapacity of that lady whom you are representing, we have entertained it. Unnecessarily.
He has started with giving the wrong information in the affidavit. Now, because he's getting a chance, he's blaming the others.
This writ appeal and the review petition have been taken up together in peculiar facts and circumstances of the case. So stop. Indisputably, there is fixed deposit. Where is it?
You last order to a printout, last order to a printout.
There was a fixed deposit account in the name of
Samaru.
Samaru Meher.
In the name of Samaru Meher, who died on
1/3/2020.
1/3/2013.
No, 22.
On 1/3/2022. So stop. Who is Rohit Meher?
The nominee.
Nominee.
Is the nephew, the nominee.
Nephew.
And Chitram Meher?
Brother of the deceased.
What is his name?
Chitram Meher.
He also died.
Yes.
Sorry, his son. Rohit Meher, comma, nephew of the said account holder was made nominee in the said account. Stop. Rohit Meher is son of late Chitram Meher, comma, a brother of the deceased account holder. Stop. Next. Circumstances compel the legal heir of the account holder file a writ petition, widow of the deceased, file a writ petition before this court giving rise to WPC number 2655 of 2022, in which Chitram Meher was impleaded as opposite party number 2 and described as the nominee. So stop. Where is that order?
No, my lord, he was not described as a nominee.
Then he was.
Only opposite party number 2. But in counter,
Oh,
they
please,
say
please.
opposite party number 2 is the nominee.
Relied.
All right. Where is that order? Writ petition.
Writ petition order. Can be opened. Writ petition copy ଅଛି record ଟା physical copy ଦିଅନି. Scan the order. What was that earlier writ application you had filed in the year 2018? What was that for?
That is when the bank did not release the amount, filed a writ application before the Honorable Court. But the Honorable Court directed the manager to consider his application, her application. But it was not considered.
Order dated 2027.
Here. Page number 2. The widow of the account holder sought a direction from this court to the bank to disburse the money deposited by her late husband. So stop. It is mentioned in the order that brother of the deceased was nominee in respect of one of the fixed deposits.
Because there were 4, 3 were released and fourth one he was. That is the submission, but it's not there. No, I was 4. This week, this week, I mean, I have objected to the. Yes, also not stated the legal.
But in the counter, it will be.
I know. So what? That report that he objected to the legal law. I have said please do it. Officer of the bank. The petitioner stated the nominee form of the authority. This was the clear boss. Objecting to release.
So when some other writ petition was filed in 2018,
My lord,
whether any writ petition was filed in 2018 also,
my lord,
who had filed?
Lady.
that fellow, the opposite party number 2 filed one writ application, and the lady widow filed one writ application. His
He
application,
was not a widow before 2022. According to him, he died in 2020.
no, in 22,
The brother died.
my lord,
When did he die?
he died
The
in the,
account holder.
in the year probably 1916,
Have you given all the dates in your affidavit?
2016, my lord.
Mr. Misra, in your comprehensive affidavit is have all the dates been given?
We will pass orders tomorrow. It is impossible for us to comprehend. So have you, Mr. What's your name? What is your name?
Madhusudan Datta.
Mr. Madhusudan Datta. The regional manager, which bank?
State Bank of India, regional manager.
Bank of India. Which place?
Bargad.
Regional manager.
Bargad is personally present in compliance of this court's order. The branch manager of
You are the branch manager?
Yes.
Your name, please?
Nisikanta Nayak.
Nayak,
of Bargad branch,
please give the names in a slip.
Dungripalli branch.
Dogripalli branch of Bargad is also present in compliance of this court's order dated so and so date. Stop.
Your lordship, respondent number 2, your lordship may be dispensing.
Yes, you were doing it.
This. So he will not object now.
Madam?
He will now not object.
No, your
The respondent number 2 is also present in court. So stop. What is this matter on Monday? Tuesday. On Tuesday. For passing appropriate orders. Now let us understand. He died. Who is entitled?
nominee. The nominee.
Nominee has to sign and
Who is entitled?
entitled the legal.
It's a regional manager. We
Nominee
are
has to
putting
sign
this
the form.
question to you. After her death, his death, who is entitled for the amount?
Since the account nominee is there, nominee is entitled to.
You will record that and then you will
No.
Since there is a dispute between nominee and legal.
Just a minute. He died. Who is entitled to receive the amount? Nominee.
Yes.
Right? And nominee is required to pay the amount to the legal heirs or whosoever. Nominee has no right to retain that amount. All right. The question is, who are the legal heirs? Now, suppose he had died without any nominee, the amount would have gone to whom?
Legal heir.
Who are the legal heirs in this case?
Only wife. Only wife. Two accounts are disbursed in favor of that widow. But one account was not disbursed due to nominee.
We should not put any question. We should just decide. Just wastage of time. Dispensary. Hmm?
Item 28.
My lords, beg pardon. My lords, I'm appearing on VC.
Yes.
My lords, once again I beg pardon, your lordship, because last two occasions I couldn't appear due to the surgery of my wife. So right now, my lords, I've gone through the status report that OP number 6 has filed. But my lord, they have only filed the places which is complete, and the incomplete stretches of the road they have not mentioned in that status report, my lords. My lords, that's why I request this honorable court to grant me 15 days time, that up-to-date videos which I have submitted earlier, I will submit once more to now situation, my lords.
Present video.
Present video, my lords. Video and photographs I will submit, my lords, and there are also that Sadapada bypass, that one side of the NH is not complete and recurrent accidents are going on. Sorry, beg pardon, my lord. The recurrent accidents are going on and 2-3 lives have been gone, my lords. There is the paper cutting is there. I will just translate it and file also before the next date, my lords.
What is this matter about?
Well, the matter is about that the condition of the road is not good from Panikoili to Rimuli. That is a stretch of 163 kilometers, my lord. And my lords, only 2 toll plazas are permissible in this road, in this stretch, according to 60 kilometers norms of NHA. But illegally they have installed and collecting from 3 toll gates, my lords.
So what are we? Are we the chief engineers? Are we the executing agencies?
No, my lords, my
Are
lords.
we here for the maintenance of national highways?
No, my lords. My lord, the local people and the commuters.
Local people could have gone to the top brass in the executive.
My lords, if my lords permit me 15 days time, I will give
No question of 15 days. We should understand our own limitations. We have matters to adjudicate upon.
Then my lords may kindly dispose of the matter in town, then direct the OP number 6 to give a detailed status report and finish the
No question of any direction. Had you approached any authority?
Yes, my lords. Time and again we have approached.
Where is that? Where is that?
My lords.
Where is that? Before filing the writ application, whom had you approached?
My lords, 61. My lord, annexure 10, page 115.
Yes.
My lords, I have approached the Principal Secretary, Commerce and Transport, National Highway Authorities of India, my lords, Collector Jaspur, Collector Keonjhar, and as it's the mining belt, I already also have sent the representation to the Secretary Mines, Honorable Minister Mines.
So whether any affidavit has been filed?
Nothing, no, nothing, my lord.
Affidavit has been filed.
The highway it has been filed.
Only OP number 6 has filed, my lords.
So have you filed any reply?
Yes.
Yes, my lords.
What? See, this will be an endless process.
My lords, can I say something, my lords? Otherwise, I request my lords to withdraw. I want to withdraw the matter with liberty for filing a better application, my lords.
Not better.
My lords, a lot of issues are there in relation to the road condition and the collection of tax, my
The
lords.
question is that are we here to monitor the national highways?
My lords, when the authorities are putting a deaf ear, my lords is only there to.
Who is for the highway authority?
I am for the National Highway Authority on behalf of Mr. Umesh Manthi.
So why are these complaints coming?
My lord, it was initially in the year of 2021. Thereafter, we have rectified that. We have filed the status report presently what is done.
Yes.
If there is any other grievance, he may raise separate representation to the different
My
authorities.
lords.
We will take care of.
No, why should there be any occasion for them to raise any grievance?
My lord, once the Gayatri construction was engaged, her agreement was cancelled. Thereafter, another agency was engaged. Her agency also terminated. Thereafter, ARSS was interested. He completed that construction. So there was some time limit. Within that, this overbridge and slabs
So
and
this is what is the stretch? What is the length of the stretch?
136 kilometers, my lord.
From where to where?
From Panikoil to Rimuli. Panikoil, it is in the way of Baleswar, Kotak to Baleswar.
Panikoili is Baleswar or Jajpur?
Jajpur,
Yes.
in the way of Kotak.
Is it used for the Tata project? That road? No.
No, man.
Why they saying the trucks are being?
Please, 160 kilometers, my
All
lords.
right, all right. No, it is your duty. Once you made that, it is your duty to maintain the national highway. So that you have to do.
Development of the status report on 17th July. We have filed.
17th July, where is
Yes,
that?
my. It is there, my lord, before.
My lords, on the status report, only the roads, the stretches which are complete, they have filed only that, my lords. Apart from that, the many stretches are incomplete till date, my lords.
Oh, no, you are concerned with what? About whole country or this 136 kilometer?
No, my lords. I have only filed this PIL for that 163 kilometer stretch, my lords.
And Mr. Samal, another thing is, once they repair it because it is being used, it can't remain like that. So this wear and tear will continue and they have to keep it.
That part I understand. But some parts are there, some stretches of the road are there which is totally untouched, my lords.
Not there. Like 2L.
Inspection report updated.
No, that is 2,000. Like 2L.
1-2.
No. That is 24/4/2023. Next year.
Latest one is 13.
13. Please give us your copy of that affidavit.
No.
No, that's it.
I think 18.7.
18, today's what?
It is stated by Counsel for the NHAI that an affidavit has been filed
1 week?
on 17/7/2024. 18/7/2024, bringing on record the latest status report as regards the condition of which NH?
Recorder ଅଛି କି ଦେଖିଲେ?
For 60.
File ଟା ଦିଅନ୍ତୁ। File ଟା ଦିଅନ୍ତୁ।
21520.
File ଟା ଦିଅନ୍ତୁ।
NH 215. What is the stretch?
That's 163 kilometers, my lord.
From which point to which point?
It is from Panikoil to Imuli.
From Panipoli to
Remove.
So let's this matter. This said affidavit is not there on record. Let's this matter on 2 weeks with the said status, said affidavit on record.
Item 29.
That's okay.
That was there before your lordships on the last occasion. From the impugned order of the Honorable Single Judge, it was the requisition, my requisition was dismissed only on the ground that no such objection was ever raised earlier. Your lordships, I wanted the State Council to say whether any objection was there by me. There are at different points of the records, I can show my lord that there was objection at the instance of the petitioner also.
Yeah.
Even in the counter filed by them before the Honorable Single Judge, they have admitted that I have raised the objection.
The counter you have referred to an objection.
Yes,
That I-
that's page 54.
Where is Mr. Mahanti?
Month is resigned word, so he.
Okay, please.
They have even given the date that on 28/8/74, the petitioner claimed for exemption.
Where is that finding of the Lord Single Judge?
At page, in annexure 4, my lord. At page 69, I think there was some difference of dates with page numbers. And annexure 4, the impugned order. Paragraph 2, my lord. There is no filing of objection by the petitioner in the original proceedings. Sri Sahul and counsel failed in establishing the petitioner's case on such aspect, if any, in the lower authority. Even this court is also unable to find any such observation, neither through the discussions in the original order nor in the objection in the original case, giving stress on the foundation of the petitioner. Therefore, this honorable court has dismissed it. In fact, my lord, 2 writ petitions were filed, one by me and one by my sister. The writ petition filed by my sister against the similar order was allowed. So far as my case is concerned, it was observed that no such objection was raised.
Yes, what is your stand?
Lordship, in fact, we felt, Lordship, I think Lordship, no letter has been communicated to the authorities calling for the OJA records, but from the Lordship, paragraph 8, which my friend has referred to, Lordship, I find that page 54, in her objection petition dated 28/8/1974 is written that, but so far that date is concerned, Lordship, this also, Lordship, I find from that counter, it relates to a proceeding under the Lordship, certificate proceeding under the OPDR Act. So objection in the OPDR Act or objection before the Lordship, that is the confusion, Lordship, now I get.
Also stated that he did not turn up to file her return.
Yes.
Within the stipulated period for which sumoto case under section 142 was taken.
Right, Lord. So objection, whether this objection relates
So
to
how
that.
do you say that objections were filed?
Yes, ma'am, you will also find from the impugned order, from the order of the collector also, additional district magistrate also that is recorded. At page,
No, but where is the objection?
objection readily, I don't have it for the reason that the counsel who was conducting the case before the revenue authorities, he died due to COVID. So there is nobody.
So the objection must be there on record.
That is there on record, but that is there on record, but I don't possess it. In the LCR, it will be there. But from the orders passed under section 59(2) also, my objection has been taken note of.
Let us see.
Yes, ma'am. If you're also, for convenience, I have just prepared a small note.
Yes, that is there, but from the order of the collector, let us see whether
Yes.
there is any reference to the
Your
objection or
losses
not.
are find at page 20. Second paragraph. The brief facts of the case is that Tahsildar Raigada had initiated a sealing case bearing number so and so against Bhakta Priyamba of Raigada having so and so acres. The land is recorded dry in the ROR, but the Tahsildar, while disposing of the case on 26/2/76, has classified all the lands as class 2 and vested 12.61 standard acres to the government as sealing surplus land. Being aggrieved on this, the landholder went in appeal and revision. Both the appellate and revisional authorities have rejected the claim of the petitioner and upheld the orders of the lower court. Lastly, the petitioner filed a writ petition before this Honorable Court in OJC 2165 of 81. Honorable High Court, in its order dated 28/8/91, had remanded the case to the ADM along with two other revisions, 8/92 and 9/92, for inquiry and dispose of the cases in accordance with the observation and direction given in OJC 2163 of 81. The nature of these two cases started against G. Sarojini and so and so. The observation of the Honorable High Court in OJC 2163 of 2001 is, it is necessary that revenue authority should have investigation if the lands were irrigated lands as defined. The statements of the Secretary of the Society is confusing and therefore it is difficult to draw any conclusion therefrom. If the lands of the petitioner were being provided with water for the purpose of irrigation of by the society, the records of the society would be the best evidence and endeavor should be made to find out if the petitioner was charged with the water rate for the purpose of irrigation so and so. That would be the best evidence. It shall be open to the parties to adduce such further evidence as they choose. With the aforesaid direction, we remit the matter to the ADM for further inquiry. Next page, ma'am. On the direction of the Honorable High Court in OJC so and so, dated 28/8/91, is also similar to that of OJC number so and so. As that, I feel it necessary to pass an analogous order in all the above three revisions cases. The observations and directions of the High Court so and so has dealt with. Then, at page 24, the contention of the advocate for the parties is that all the lands involved in OLR case number so and so are as dry in the ROR, but revenue officer come Tahsildar Raigada, without verifying, held that the lands are irrigated.
But where is the objection?
My objection, my lord. You will also find from Annexer 2 at page 37, paragraph 8, I have gone through all the evidences and documents on record.
It is evident from the objection on the draft statement.
No, see, the specific finding of the learned single judge is that you did not file any objection in the sealing proceedings. How do you overcome that finding?
That's my Board of Revenue, while passing the impugned order under section 59(2), has observed like this at page 37. I have gone through all evidences and documents on record. It is evident from the objection on the draft statement filed by the opposite party. That's me. Available in the LCR. That the suit land was irrigated. So objection I have filed. That has been taken note of. Honorable single judge also says that from the reading of the impugned orders also, that nothing is found that there is any objection. But there are objections. And in fact, after the remand order, the ADM has passed an order after inquiry saying that there was the lands were not irrigated and of class 4 and accordingly is allowed. Thereafter, after the impugned order under 59(2) was passed by the member Board of Revenue holding that the lands are irrigated lands, one of my sisters who has also.
So we are calling for the original records then.
Yes. It will be better. I produce all the records, not so both revision and original case.
Call for the original records of what is the case number?
Not so OLR case number 8/92.
Huh?
OLR revision case number 8/92.
No, OLR case number.
Before the Tahsildar. No, objection will be before the original authority notes. Because these are appeal and revision. Revision authority notes. I will produce all the records, relevant records notes, so that can be records will also simplify.
Enable an AGA to produce the original records of the concerned sealing proceeding.
Some time may be granted because all old records I will take some.
When?
4 weeks. 4
weeks.
Item 30.
Yes.
In item 30, there are 4 cases. In first case, my learned senior has appeared. If that will be decided, that will cover all the cases. But in rest 2 cases, notice has not been issued. The leading case is where my learned senior has appeared.
No, but in the rest 2 cases, notices will have to be issued.
They're all individual applicants. So they independently filed writ applications. So those writ applications were disposed of in a common judgment. But writ appeals have been filed against the writ order. So therefore, they have not been noticed. Appeal or SIP, I don't know.
Notices will have to go.
That in that case, notice on limitation is to go because there is a limitation in other cases. But only if that first case is decided, that will cover all. The principle is decided in the. There, my learned senior is appearing.
Yes, that is where the technical problem.
No, that I am not saying.
So according to you, since he is appearing, no other person is required to appear.
That because My lord,
I
Your Honor,
think,
senior is happy.
the electronic notice can be given
All right.
is available so that sort date.
So
can be
notice. Which sub item?
Madam, that in that case, Your Lordship may, in that review case, I have given note that Your Lordship may see that the writ appeal
Item.
300 of 2024. In that case, I have served copy on my learned senior. He is appear in that
802, who is appearing?
802 my learned senior is appearing.
300?
300, I have served copy on him. He to appear because that man that
All right.
review.
300 Lordship numbers, a review application was filed. That was allowed. Since Your Lordship asked him to file a writ appeal, or he himself chose to file, he has filed and received a copy. So that can be taken up along with my case.
The same respondent.
Right.
So what about, which are the cases in which notices are required?
My lord, required 1791 of 2024
1794 of 2024
and 1794 of 2024 and 1796 of 2024.
and 91 also.
91.
91, 94,
96.
96.
My lord. They are on the question of limitation.
Issue notice. Both on limitation and main matter. The requisites. Week. 4 weeks. 6 weeks. 6 weeks. 6 weeks.
My lord,
List
in
these
one,
matters.
sorry.
4 weeks. So list these matters on 6 weeks. 6 weeks.
In 1791 and 1792 and 1796, I have served copy on which is appearing for opposite party number respondent number 2. So notice to go only respondent number 1, private respondent. I have served copy on Mr. Sharma.
On
Mr. Sharma, who is appearing for respondent number 2.
respond number 2.
My lord.
Notices to go to respond number
1 only.
I am not in respondent number 2 in all the cases. In one of the cases, I am respondent number 2.
You'll also may see that 1791 is for appearing for respondent number 2. In 1794, he is appearing for respondent number 14. And in 1796, respondent number 11.
Performer.
Take notice on all the respondents or?
Except this, I will take notice on all.
Have
the
you filed your wakalatnama?
Because last evening they served the copy on me, my lord. I have sought for instruction from a client. Within a day or two, I'll file the wakalatnama.
Issue notice to all.
Well,
The only advantage he has got, he doesn't have a stake, but he is a counsel.
I have been made a party, my lord. Again?
Stake, but brief.
Performer of the quality. I'll sail through, my lord.
Item 31.
no, sir. This item, not so waste of lordship's time. My senior is ready in this brief plot. I was trying to, because last occasion my senior made a mention that he is already ready. He will address the lordship. So lordship put it specifically today. Because it's a lordship.
31 is contempt.
No, not contempt. Your lordship wanted to dispose of the writ application which has been filed, not challenging the order of not so cancellation lease in a Khasmal land. Not a bit not so complicated. I was preparing my note. So some time, your lordship, my
As
senior
requested
agrees
on
not
behalf
so.
of the respondent.
Lordship may kindly recollect, my lord. Lordship may kindly recollect. On the last occasion, I had said that this is my 8th visit, and the Lordship said I will not allow the 9th visit. Your Lordship may kindly recollect, my lord. This is a statement fell from my lord.
No, age which is so far as approaching this road is concerned, not
Yes,
approaching.
If we can modify our orders, we can modify our observations also. So, and that is a genuine ground.
I don't dispute, my lord. But the issues which I want to raise before Lordship,
Since my learned friend is not ready, I don't want to waste time, my lord. But the issues which I want to raise before my lords, it is settled by a number of judgments of this honorable court and not a single departure of that. And also rightly, your lord, it has fallen from my lord Chief Justice on the last occasion. As to whether this is a case of resumption of a customary lease or a case of cancellation. My lord, it's a case of resumption. And with regard to resumption, there is no quarrel with regard to the proposition of my lord law that has been set out by this honorable court. Lordship may fix up a date, my lord. I have prepared.
Please do it. 1 week.
1 week.
Yes. 1 week. Next Thursday.
Can it be 1st of August, my lord?
As requested on behalf of the state, this matter on 1/8.
The interim order to continue.
The order shall continue in the meanwhile.
My lord, can I make a prayer, though not usual, my lord? But also can fix up a time, my lord. I'll meet 2 o'clock or
2 PM है क्या?
1/8 can.
oblige.
Yes. Item 32.
Listen, item 32. So now, decision has been taken to create an executor post for the petitioner and appoint him as junior engineer mechanical in view of lordship's order. So now the file has been endorsed to the concerned department. Some time for creation of that post and giving appointment. We have decided to regularize the services.
How much time?
2 weeks time. In the meantime, we'll do it.
No one appears on behalf of the petitioner.
Lordship, I am there on behalf of the petitioner.
This matter on 2 weeks so as to enable the contemners to ensure full compliance of this court's order.
Item 33.
Violation of which has been alleged.
33, your lordship can dispose of the matter where there was a direction to the collector to assess the market value of the land which has been acquired by the petitioner to be paid by the Ames. Now it has been assessed by the collector. It is 3,50,000 per acre. Accordingly, they have to do it. It has been also communicated to the Ames. I can give a copy to my learned friend who appears for the Ames so that they can proceed with the matter.
I will take instruction, my lord. Mr. Raut is out of district. So, lordship.
Mr.
My honored senior, Mr. Raut. London, sir.
So what do you want?
I will take instruction.
How much time will you take to?
No, I've done my job. There was a direction to the collector to assess the market value of that land, and we will communicate it to the Ames. We have done it. Now it is between the Ames and the petitioner. With regard to payment of that.
Was there any direction to Ames?
No, there was no direction to Ames. Direction was to collector to assess the and communicate it to them.
We are dropping the contempt proceeding. Where is the order?
Mr. Lordship, kindly look at the order. Page 7, Page 7 is the order. The operative portion is 8,
9.
Page 9,
Sorry, there is nothing. The present contempt application, the petitioner has alleged disobedience of an order dated 14/3/2023, passed in WPC number 4656 of 2015, which was disposed of with a direction to the collector Khurda to act upon a letter dated 9/3/2023 issued by the senior administrative officer and DD bracketed A in charge Ames, Ames order se dekh lo, were assured to make assessment of compensation amount so that the benefit could be extended to the petitioner as expeditiously as possible. Stop. Mr. AGA, Mr. Samant Rayal and AGA has informed this court upon instructions that assessment has been made by the collector and it has a collector. So stop. It contains that court's order dated 14/3/2023 now stands compliant with. Stop. He has produced before this court. Where is that? Give a copy.
I will also dictating, I will give a Xerox copy.
So he has produced before this court a copy of the assessment.
Communication along with the assessment, communication to AIMS, my lords.
A communication to the AIMS dated 29/6/2024 along with the assessment done by the district level committee
Committee, my lord.
in its meeting held on 27/6/2024. Full stop. Next, in such view of the matter, the present contempt proceeding stands dropped. Full stop. The petitioner shall, however, be at liberty to pursue his remedy for payment of compensation before appropriate forum in accordance with law.
Item 34.
Obviously. 34, may I please your lordship, my lord. As per your lordship's direction, the Tahsildar initiated an encroachment case in the year 2022, my lord. The encroacher unauthorizedly encroached the road, my lord, government road. And from the year 2022, that encroachment case is still pending. So I filed.
So what is the order?
My lord, still now he has,
What is the order?
my lord.
So page 6 of the brief, my lords. Page
That is
6,
13/4/2023, my lord.
given the limited nature of the prayer, it
So
is
there is no direction.
And still now that encroachment still is pending.
Maybe,
And
maybe your no contempt.
my lord, he has already blocked the road, my lord, the enclosure, my lord.
Encroachment case has been disposed of or not?
No, my lord, that is still pending, my lord.
notices have been issued. They've been given a option, my lords, opportunity of so
But
called. They have
because
so
the
called.
court says that you should dispose it off.
My lord.
Where there are so many encroachers who have given them notice. They appeared to lawyers, they filed their so cause. Now they've claimed that they are landless persons, so it should be not settled that we are inquiring. So because of that, it's taking time, my lords. Otherwise, it could have been evicted forthwith.
Maybe we will go by the order,
Loss of great meter will dispose of by evicting. That's
somehow or the other.
we'll do it. Loss sometime we'll do it, Milos. Because there is a provision under the OPL Act for settlement in respect of landless persons. Now they've come up with application saying that we don't have any land. That will do and take a decision, Milos, forthwith.
This matter on 4 weeks for the contemners to inform this court about the compliance of this court's order dated 13/4/2023, passed in WPC number 30094 of 2022.
Item number 35.
35, Your Lordship, I pray for short accommodation in this matter. Mrs. Pamirath is on her legs before another coordinate bench. Your Lordship.
As requested, let's this matter on 1 week.
Grateful.
Yes.
Item 36.
Item 36, may it please your lordship. My lords, I am appearing for the appellant. My lords, facts of the case are that the appellant had purchased a property through e-auction from the opposite party bank. Your lordship will find the e-auction notice at page 10 of the writ application.
Yes.
As per the e-auction notice, my lords, the area of the land was 25 decimals. The ROR also reflects the area of the land as 25 decimals, which is at page 12, my lords. The sales certificate is also issued for 25 decimals. After the sales certificate is issued, the appellants, by way of a private armine, measure the land. And as per the report of the armine, your lordship will find that report at page 19 of the writ application. The field area of the land is only 18 decimals. If your lordship will see page 19, it is only 18 decimals. Plus, thereafter, I filed multiple representations to the bank and I asked them to refund that excess amount, which is an amount of odd rupees 9 lakhs, towards 7 decimals extra land for which I have paid. My lords, because they do not take any action, I approached this honorable court, and your lordship will find the impugned order, which is at page 14 of my memorandum of appeal. My lords, your lordship may see para 5, page 15.
Yes.
Learned counsel for the opposite party submit that the petitioners were aware of the size of the land at the time of transfer of the said property to their name, and they purchased with sufficient awareness. The principle of caveat emptor should have followed by the auction purchaser at the time of purchase. Considering the facts and submissions, this court is not inclined to consider the prayer made by the petitioners. On this ground, my lords, my writ was dismissed. My lords, my first submission is that the opposite party themselves admit, which is reflected in paragraph 5, that they have indeed sold an area through e-auction, which is deficient of the area that they have published in the sale notice, in the e-auction notice, and everywhere. Secondly, my lords, the moot challenge is the principle of caveat emptor. My lords, there is a parallel duty on the bank, which is a principle of caveat venditor. So,
Where is the notice?
my lords, the sale notice, your lordship may take the writ application, page 10, Annex 1. It is in Orissa, my lords. May I request my ladyship to... My lords, I can read it. I can read it, my lords. It's just not very legible. I can read Orissa, my lords. Very well, I can read Orissa. No, my lords, I will just place the relevant portion I have highlighted. I'll place it, my lords. My lords, your lordship will find column number 3, my lords. If my ladyship has, my lords, column number 3. Page 10, column number 3. Your lordship will find the area, which is 25 decimals. That is first, my lord. Second, the e-auction notice clearly says as is, where is basis, which is also your lordship will find, in fact, on the first, the second paragraph, which is in Orissa, my lords, Jeuthare Jepori Ochi, which means as is, where is. So now, my lords, the bank is taking advantage of this as is, where is, and is putting me in a position where I have to pay a certain amount of money for the land which has not been sold to me. This is the argument which has been made by the bank. And my lords, my important submission is that the principle of caveat emptor has to be read with the principles of caveat venditor. And the principles of caveat venditor...
Did you have any opportunity to visit the plot or the house?
No, my lords, I did not, because they took some time to give me possession. After the sale notice was issued, the possession was delivered to me 3 months later, which is why I...
Did you, when the auction notice was issued?
Yes, my lords.
Did you verify about the location, about the size?
My lords, as per principles of caveat emptor, I did encumbrances, everything, but the physical land was not verified. And in good faith, my lords, in good faith. just to file an affidavit. There is an order also, speaking order, but they did not file an affidavit. Let them file an affidavit on the status of the
Let,
land.
no, not on the status. Let a counter affidavit.
Yes,
Let a
please.
counter affidavit be filed on the bank within 4 weeks. This case on 6 weeks. Time in the meanwhile may be utilized by learned counsel for the appellant to consider the counter affidavit and file reply if so required.
In 37,
Obliged, Your Lordship.
Grateful.
We are appearing, Your Lordship. My lord.
37.
These are these.
I have the authority to disconnect number 456. Just input to my. Here you will accept this issue. Document number 400/2054 has already decided the issue. I am serving the copy that WA number.
We are there, Your Lordship, in these matters. Let him serve a copy. So we will be, if Your Lordship so permits, we will argue the matter on Tuesday.
Few seconds.
Please give it.
Tuesday, Your Lordship.
Huh? Tuesday,
30th. 30th.
Yes.
30th.
কপিটা দেখো
স্যার আমাকে ওটার কপি দিন।
That the honorable solicitor's judgment has been relied.
Please.
But if you also look to paragraph 5, I have not seen the details. But the counsel appearing on behalf of the appellant has not disputed the finding of facts. That some fraud has been committed or something. Here is not that case.
Not.
Anyway, also keep it to Tuesday, we'll address it. I think that case is different than this.
See copy.
Practically, it is an order of concession, on concession, nothing.
No, this was not on concession. This was
Because
on the finding that this certificate was obtained fraudulently.
That is that. The petitioners agreed that there is some that case. The appellant.
Who is this? Stop that.
It will be kept in record, but I have given the 11 provisions.
That can be kept on record on 30th also.
Only the relevant provisions have been.
As jointly requested on behalf of the
Appellant.
appellants. List these matters on 30th.
30th.
You know, 38.
38, my lord. I am appearing for the copy of yours.
Demolition structure problem that was there of that Keeper Association.
Copy of yours. I'll file. And not only just one structure, there are several structures are there. They only the government spot up this only one structure and demolish it. What's about the others?
The inquiry was conducted, Your Lordship.
I will file a detailed reply, not your
Who
lordship.
are you?
I am for the OP number 7, against whom, my lord, all allegation has been made.
So that we cannot deal with. Who is for the, what is your grievance?
Lordship, that I am for the petitioner. The main grievance is, or Lordship, according to my read petition, is against annexure 4, where it is clearly stated by the forest range officer that the complete violation of the forest land that is encroached of the forest land by some private parties, and for that reason, Lordship has directed to take necessary action on the first to state. And
So they have taken action.
Yes, my lord.
So you are satisfied.
Yes, my lord.
Then you can withdraw it.
My lord, so far as my
How
humble.
can you oppose?
My lord, I am not opposing, my lord.
Mr. Counsel, if something has been done against you, you can take a recourse to law.
I am not against that, my lord. My humble submission is, he filed a case against me that I have occupied that. All right, government has taken action in accordance with law, demolished that. But in the very same place, another 10 to 15 structures are there.
Very good. You file another PIL.
As your lord.
All right. Learned counsel appearing on behalf of the an affidavit has been filed. You have not filed. Learned AGA representing the estate has submitted that the grievance of the petitioner as raised in the present public interest litigation has been substantially redressed in as much as illegal structure constructed by opposite party number 7 over a forest land has been demolished. So stop. Your affidavit is there. Next. Learned counsel appearing on behalf of respondent number 7 has appeared and has submitted that though his illegal structure has been demolished by the state officials, there are other many illegal structures standing over the forest land which have not been demolished. So stop. We need not comment upon this oral submission in the present proceeding. So stop. It is expected that the concerned state officials shall act in accordance with law in such cases also. So stop. This writ petition stands disposed of with the aforesaid observation. Yes.
Item 39.
Oblige, my lord.
My pleasure, Lordships. Lordship directed collector OP number 13 to file the affidavit. Collector's affidavit is yet to come, Lordship.
What is this matter about?
It's a matter regarding the construction of 200 feet wide road, urban road, BDA road, Bhubaneswar Development Authority Road. It's forays into a Gram Panchayat area illegally and unauthorized by the engineering department, engineers, which where the 450 Adivasi people are living is a forest land, Gram Panchayat revenue forest land. It's not coming under the urban land, BDA. It is forays because to protect some few influential persons whose boundary is just touched by the
BDA road, which is supposed to be constructed and it has been notified in Gazette. They are diverting and realigning the road into a Gram Panchayat area, making it chaotic. And it is unauthorized and also not in compliance as per the mandate of the ODA Act, Orissa Development Act. So forest land, they are now resorting into, they are foraying into a Gram Panchayat area. It's a urban BMC, but the counter affidavit of engineers has come. They say that it is within BMC area, but the collector instruction might have been it's a Gram Panchayat area.
I have instructions from Sarsikan and the RI before your lordship. Lordship has filed an affidavit also. The report states that it is Anavadi land, your lordship.
It
It's a forest land, forest Annavadi land. And Adivasi people are living since 3 generations.
It's an encroached land by the Adivasis, your lordship. But
Since 3 generations.
land says that Anavadi and Isam is jungle, your lordship. Jungle means forest land.
Forest land. They have not yet obtained the clearance from. They are under Forest Rights Act. They are supposed to live.
As your lordship, we have not used. We have built the roads wherever the BDA has given us freehold land, your lordship.
So wrong. Lordship is wrong because they have constructed into a forest area. I can show. I can file an affidavit. They have misled the Honorable Court by filing false affidavit. I can show that they have constructed a road into the forest land. They have already constructed, but they stated that we have not yet started. So law mandates that certain, even they can take the Gram Panchayat area into the urban area, but certain principles of law that that has to be notified and many things has to follow. But without following the same, they are foraying in their unauthorized and illegally constructing the road to protect the boundary wall of a golf club and the boundary wall of which is also encroached, the forest land being encroached. The Adivasi people are now sandwiched, they are squeezed. Only they are living 3 acres of land. Entire land belongs to the forest area. Some powerful people.
So you're saying Adivasi people are staying in 3 acres of land?
Only 3 acres they are confined now. That is wildlife, Chandaka Wildlife Division, just adjacent to the wall. The trench, elephant trench, adjacent to that they are living since 3 generations. And the road 2, Annex 2, Lordship, kindly have a glance. Page 22. This is unauthorized.
Yes, my lords, I will file a counter, but may I make it clear, Bhubaneswar Development Authority is not going to construct this. The construction is by my lords, the chief engineer, my lords, opposite part number 8, 9 to 14. They filed a counter giving the detail why, what for, and the region of construction and necessity of the construction. That counter copy, I think, government filed counter, no?
Will you file?
The copy of the counter may be given so that I can bring any additional.
Lordship directed collector to file, making coordination with Forest Department, SCSD Department, and the local inquiry. Collector has given the instructions, but the engineering department has filed a false.
Did you meet him?
Lordship?
Did you meet the collector?
No.
So how do you know that the collector has given instructions?
The last time the AG has submitted the.
How are you sure what instructions were given?
No.
Don't say that.
No. The last time it was submission of London AGA that collector has given instructions. So we expect the collector has to file the counter affidavit.
This matter.
Lordship's direction was to file collector to file the counter affidavit.
2 weeks. Yeah. So as to enable. Earlier direction was given.
Collector to file, yes. The first order. 4
weeks. Oh, but the government has filed, then why? Was there any direction?
Yes, collector to file affidavit 3-4, the first order. That's it. 3/4/2024. Opposite party number 13 must be, the counter must be filed by OP number.
You have received copy or not? Or you have received the copy or not? Or you have received the copy of the
Copy of
counter?
counter of the engineers. Plus
କହୁନାହାନ୍ତି opposite କହୁନାହାନ୍ତି କେତେ copy କରିବେ?
Sir, three construction engineers are in the certification.
Then why collectors would file affidavit?
Lordship directed, because they are stating that
Huh?
they are stating that it is not within it's a Gram Panchayat area. They state that it's a BMC area. That is the dispute.
And the
So-
collector will say something else.
The collector definitely is a collector.
Sorry.
I'll
Sorry.
take time, 1 week's time to file rejoinder.
Tomorrow, Monday.
Monday.
Monday we will take up.
Obliged.
And no further affidavit is required.
I beg pardon to mention item 49, your lordship, it did not reach today. If your lordship could fix the matter as per your convenience at 2 at 2 p.m. on any day.
On Monday, make a mention. Monday.
All the matter will come.
My lord,
All
item
the
number
matters.
59. I pray item number 59 may be taken up on Monday.
Monday.
May I be pardoned to make a mention, my lord? Item 40, my lord, I have filed an IA for addition of party, my lord. It has to come under the headings orders, but it has been coming under the heading admission. I pray for it to come under the heading order so it can be taken up.
That order can be passed under that heading also.
My lord, 51, my lord, 51, my lord, 51, there is an interim order. I only pray, my lord, for the continuance of the same. My lord, obliged.